2021. I'd like to call the Water Quality Control Commission meeting to order. We do have our agenda. It was posted. So item number 1 would be to ask Ms. Jones to call roll.
Okay, good morning, everyone. I did get a message, and I think Vice Chair Wade, you did as well, that Commissioner Candelaria will be absent.
That's correct.
So I will note for the record he's absent. Commissioner Certain.
Here.
Commissioner Dominguez.
Present.
Thank you. Commissioner Hutchison. I know I saw your name. Commissioner Hutchinson. Well, we'll circle back. Commissioner McWilliams.
I'm here.
Commissioner Musharafi. Commissioner Modi.
Present.
Thank you. Commissioner Patton.
Yes, I'm here.
Thank you. Commissioner Rader.
Here.
Commissioner Cipher. Commissioner Thompson.
I'm here.
Thank you. Commissioner Timmons.
I'm here.
Thank you. I'm going to loop back on to Commissioner Hutchinson. I see you. Can't hear you. And Commissioner Musharafi, have you joined us?
This is
Okay.
Howard Hutchinson. My computer sound was turned off, so I was seeing everybody talking, but I couldn't get back in.
Oh, I'm glad you joined us. Thank you. I've got you marked as present. And Commissioner Musharafi, have you joined us?
Yes, I just joined here. I had some problems joining in earlier.
Okay. Commissioner Cipher, have you joined us? Okay. And Commissioner and Vice Chair Wade.
And I'm here.
Okay, you have a quorum. We have one, and we have 2 commissioners absent.
Okay, thank you. And just to introduce myself, my name is Gabriel Wade, and I am acting as chair for this meeting. We don't have this on the agenda, but I think this would be a good time for our new commission member to introduce herself. And I apologize, Ms. Stringer, this is putting you on the spot.
No problem. Good morning. I'm Stephanie Stringer. I am the representative from the New Mexico Environment Department. I am now serving as Deputy Cabinet Secretary of Operations for the Environment Department.
Thank you. Item number 2 would be the approval of today's agenda. I would like to actually make the motion to approve with a slight change. What I would like to do is move item number 6 on the agenda, which is Wqcc 2051, the triennial review. I'd like to move that to item number 9 and discuss that with the next meeting and expected upcoming matters, just so we can get to the more items of substance this morning. Do I hear a second with that slight change?
Mr. Chair, this is Commissioner Thompson. I second your motion.
Thank you. And this would request, this would be a roll call vote. Ms. Jones?
Okay, yes. To approve the agenda with the change, Commissioner Candelaria, who is absent. Commissioner Certain?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Hutchinson?
Yes.
Commissioner McWilliams,
Yes.
Commissioner Musharrafi,
Yes.
Commissioner Modi,
Yes.
Commissioner Patton,
Yes.
Commissioner Rader,
Yes.
Commissioner Cipher, Commissioner Thompson,
Yes.
Commissioner Timmons,
Yes.
Vice Chair Wade,
Yes.
Commissioner Stringer,
Yes.
Vice Chair, the motion passes with 2 commissioners absent.
Okay, thank you. Item number 3 would be the approval of the May 11, 2021 minutes. Commissioners, have you had the opportunity to review the minutes, and do I hear a motion to approve?
Mr. Chairman, this is Howard Hutchinson. I move we approve the minutes.
And is there a second? Or does anybody have any comments or changes to the minutes?
Mr. Chair, this is Commissioner Thompson. I second the approval of the minutes as submitted.
Okay, thank you. Ms. Jones, this would be a roll call vote as well.
Yes, sir. Beginning with Commissioner Candelaria, who is absent. Commissioner Surton, Commissioner Surton, how do you vote?
Abstain, as I was not present.
Okay, thank you. Commissioner Dominguez,
Yes.
Commissioner Hutchinson,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Musharrafi,
Yes.
Commissioner Modi,
Yes.
Commissioner Patton,
Yes.
Commissioner Rader,
Yes.
Commissioner Cipher, Commissioner Thompson,
Yes.
Commissioner Timmons,
Yes.
Commissioner Stringer,
I will also abstain since I was not present or commissioner at the time.
okay. Vice Chair Wade,
Yes.
Vice Chair, your motion passes with 2 commissioners absent and 2 abstentions.
Thank you. Okay, moving on to item number 4 of the agenda, which is the nomination and election of the new WQCC chair. Like I said, I am acting as chair. I myself don't feel that I would have the time to put into being the chair. I would like to make a nomination. Again, this is putting Ms. Stringer on the spot in a lot of ways, but I know that Ms. Stringer has over 25 years of water quality experience in technical and administrative matters, and I would like to nominate Ms. Stringer to be the chair of the WQCC. Got it open to discussion, commissioners?
Mr. Vice Chair, this is Commissioner Thompson. I would second your nomination. I've worked with Ms. Stringer off and on and her staff, and I think she'd be an excellent chair.
Does anybody else have a different nomination, thoughts, questions? Okay, assuming Ms. Stringer would accept, we could go to roll call vote.
Mr.
I'm sorry,
Chairman,
go ahead.
this is Howard Hutchinson. I think it's always a good idea to have the chair within the Environment Department. It makes for smoother activities for setting up the meetings and making signatures on orders, etc. I was hoping we could toss Mr. Dominguez under the bus for another round as chairman, but I think we have a good nomination. Thank you, Mr. Chairman.
Thank you, and I agree with everything you just said. Does anybody else have any input? Okay, Ms. Jones, the nomination has been made and seconded. So if we could have a
Very good.
roll call vote.
Sure. Beginning with Commissioner Candelaria, who is absent. Commissioner Surton, how do you vote?
Yes.
Commissioner Dominguez,
Yes.
Commissioner Hutchinson,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Musharafi,
Yes.
Commissioner Modi,
Yes.
Commissioner Patton,
Yes.
Commissioner Rader,
Yes.
Commissioner Cipher.
Yes.
Welcome. Commissioner
Thank you.
Thompson,
Yes.
Commissioner Timmons,
Yes.
Vice Chair Wade.
Yes.
Commissioner Stringer, although I imagine you might abstain.
I
Okay.
abstain, but I do accept the nomination.
Thank you. That's unusual. Vice Chair Wade, your motion passes. We have one abstention and one commissioner absent. Welcome, Chair Stringer.
Yes, thank you very much. Welcome. Chair Stringer, I am prepared to go ahead and run today's meeting. I didn't want to put you too much on the spot, if that would be okay.
That is very acceptable and greatly appreciated.
Great, thank you.
Vice Chair Wade,
Yes, sir.
Commissioner Dominguez. Quick question, although we do not have it on the agenda. I'm going under the assumption that you will continue to serve as vice chair. Is that a correct assumption?
Yes, you're correct. That's not on the agenda. I hadn't actually given it a lot of thought. If somebody else would like to step into the vice chair role, now is a great time to speak up. Otherwise, I'm happy to continue.
I believe we would actually have to have it docketed as an action item. So I'm going to go with the de facto premise that you're stuck with it unless we put it on the agenda down the road.
Does anybody wish to put that on the agenda down the road? If anybody would like to step into the role or has a nomination, we can put that on a later agenda.
Vice Chair Wade, this is Commissioner Timmons. If you're good with staying on, I think we should keep you, please.
Well, thank you. Okay, but if anybody does wish to add that as an agenda item down the road, we can do that at some point. Thank you, Commissioner Dominguez.
Thank you.
All right, moving on to agenda item number 5. This would be the public comment section. So this is the opportunity for any members of the public to provide any public comment. Is there any member of the public who would like to comment at this time?
I am Marisa Lamela from Vision Mobile Home Park of Kirtland, New Mexico. I would like to comment that I'm grateful for all the people that are listening and helping the community today, and the commissioners that are there that have been voted in from the people that are helping the community stay strong. And I would like to say thank you to all of you for your hard work.
Thank you, Ms. Ornelas. Is there any other member of the public who would like to make comment? Okay, hearing none. As was voted on, we will move item number 6 later down into the agenda into item number 9, which brings us to item number 7, WQCC 20-72. It's the matter of request for variance from regulations 20.6.6 by Ironhorse Permian Basin. And I think at this point, we have a hearing officer who's been appointed, Mr. Chakalian. I hand it over to you, Mr. Chakalian.
Thank you, and good morning, commissioners and the parties and members of the public. Before we begin, do we have a court reporter? We do. May I know your name?
Teresa Dubois, court reporter.
Ms. Dubois, before we begin, we have 2 hearings in which a court reporter is mandated by the rule 20.1.3. It's my understanding that in this variance petition, the petitioner is paying for your services. However, in the next matter, the Vision Mobile Home, we haven't heard back. So I just wanted to let you know that we'll get to that when we start that part of the agenda, okay? And Ms. Dubois, are you also prepared to handle the exhibits? Okay, excellent. Just wanted to make sure. Will you also be swearing in the parties? You will. Okay, excellent, excellent. Okay, this hearing will please come to order. Today is June 8th. The time is now 9:19 a.m. My name is Gregory Chakalian. I have been appointed by the former chair, but through the commission, as hearing officer in this matter. May we have a roll call of the board?
Yes, sir. Commissioner Candelaria was absent. Commissioner Surton.
Present.
Commissioner Dominguez.
Present.
Commissioner Hutchinson.
Here.
Commissioner McWilliams.
Here.
Commissioner Musharafi.
Present.
Commissioner Modi.
Present.
Commissioner Patton.
Here.
Commissioner Rader.
Present.
Commissioner Cipher.
Here.
Commissioner Thompson.
I'm here.
Commissioner Timmons.
Present.
Vice Chair Wade.
Here.
Chair Stringer.
Here.
Mr. Hearing Officer, you have a full commission minus 1 commissioner absent.
Okay, would the parties enter their appearance?
This is Christopher Atencio for the Groundwater Quality Bureau, New Mexico Environment Department.
Petitioner, we don't hear you.
Maricela Ornelas of Vision Mobile Home Park.
Ms. Ornelas, we haven't called your case yet, but thank you.
Thank you. I just wanted to make sure you knew I was here.
Yes, I know you're here.
Mr. Hearing Officer, can you hear me now?
I can hear you, yes.
Okay, this is Louis Rose on behalf of Petitioner Ironhorse.
Okay, welcome, Mr. Rose. This is a hearing in WQCC 20-72V, as in Victor, or variance, to consider the request for variance by Ironhorse Due to the COVID-19 public health emergency declared by the governor and following guidelines for public gatherings set up at the Department of Health, this hearing is being held online via the WebEx platform. If at any point during the hearing technical difficulties arise, please bring them to the administrator's attention and efforts will be made to remedy the situation. The administrator today is Pamela Jones. You can either chat with her through the chat feature or you can send her an email. It's pamela.jones@state.nm.us. The petition in this matter is the Ironhorse and the department is the other party in this. This is controlled by 20.1.3 New Mexico Administrative Code, or NMAC, and the specific subsection is 18. That outlines the course of events that we will follow today. It is titled Variance Hearing. A short summary of what's going on for the public and for members who are not familiar with this case. This variance petition was submitted by Glorietta Geoscience. That was before Mr. Rose entered an appearance. On behalf of the client Ironhorse Permian Basin, LLC. The petitioner, that is Ironhorse, purchased the former Lakeside Dairy in 2014 after the dairy had terminated its dairy operations and removed all cows from the facility. The petitioner has since redeveloped the property into a railroad terminal facility for the transfer, loading, and unloading of products. The petitioner, through its sister company Ironhorse Water Producers, LLC, also provides commercial water sales to various customers at the property. On August 28, 2020, the petitioner was issued a discharge permit renewal for closure, DP 796, under the dairy rules and 20.6.6 NMAC. The discharge permit was issued to protect human health and groundwater resource by requiring controls on the presence and distribution of water contaminants associated with the former dairy facility operations and to address permanent closure activities and oversight of the post-closure monitoring. The closure requirements include the removal of all former dairy operating structures, removal of dairy waste and waste control structures, and continued sampling of groundwater quality at the facility. The variance petition request is to retain part of the wastewater control structure for beneficial use by the current property owners. We'll hear more about the case in the opening statements from the party. There will be a designated time for any member of the general public to present non-technical testimony. This hearing will be conducted in accordance with the Open Meetings Act, the State Rules Act, and the Commission's adjudicatory procedures under 20.1.3 NMAC. This hearing is being transcribed verbatim by Ms. Dubois, who is a court reporter. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing, and I'm going to ask that the court reporter put her email in the chat feature. Thanks, Ms. Dubois. Copies of the proposed variance, the response by the department, and technical testimony that has been filed by both parties has been posted on the Wqcc website. The hearing will be conducted in a fair and impartial manner to assure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard, without making this hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence do not apply to this hearing. As hearing officer, I will make such orders as necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask all persons at this hearing to please mute their microphones unless they are speaking. During the hearing, please be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. The commissioners have received in packet the pre-filed exhibits. Exhibits are available for review by the public on the WQCC website. All testimony will be taken under oath. In this case, because we have pre-filed technical testimony, I will ask each witness to adopt their pre-filed written testimony under oath and just provide a summary for the commissioners. As hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious or unreliable. Any person offering an exhibit shall provide the original to the commission administrator, that's Pamela Jones, and a copy will be shared by Ms. Jones with everyone else. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Petitioner will present its direct testimony on the proposed variance first. Then we will hear from the department. If any other persons, including members of the public, wish to present non-technical testimony, in other words, general comment, about the proposed variance, they will testify as called upon. If you are a member of the public, please email Pamela Jones at the email I gave you before, or use the chat function to indicate your willingness to testify. Because this hearing is being transcribed, please remember that only one person may speak at any one time. Please direct your testimony and answers to questions to the commissioners. They are the decision makers. Any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. The petitioner has the option of presenting its witness as a panel for purposes of cross-examination. And I think also the department can do the same to present their witnesses as a panel for cross-examination. Okay, let's see. And then we will have rebuttal testimony if necessary, after the cases in chief are presented. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as a direct testimony. We will now proceed with receiving evidence and testimony. Do the parties have any exhibits to introduce as evidence at this time?
Mr. Hearing Officer, we have a number of exhibits that were attached to our notice of intent. And if now's the right time, we'd offer them, move for their admission.
Let me get your technical testimony packet. One moment. Okay, I have yours here, and on page 2 of your statement of intent, I have a list of 18 exhibits. Is that what you're referring to?
That's what I was referring to, Mr. Hearing Officer.
Okay. Does the department object to any of the exhibits?
No, Mr. Hearing Officer, no objection.
Okay, hearing no objection, these 18 exhibits will be admitted into evidence. And would the court reporter please take note? Thank you. And as another preliminary matter, does the department have exhibits that it wants to enter into evidence?
Yes, thank you, Mr. Hearing Officer. Similarly, the department had exhibits attached to its statement of intent to present technical testimony, which it pre-filed. Those are listed on pages 2 through 3 of that statement of intent, numbering NMED exhibits 1 through 7, and the department would move those for admission into the record.
Petitioner, is there an objection?
No objection, Mr. Hearing Officer.
Hearing no objection, 7 exhibits will be admitted into evidence from the department. And I do see that they are all marked at the bottom of each page. And let me make sure that petitioner's exhibits are all marked as well. A little differently, but IPB Ironhorse Permian Basin, I suspect that means.
That's correct.
And then we just have basic page numbers here.
I think Mr. Hearing Officer, I think all of the exhibits have been Bates numbered, so that should be what's at the bottom of the page.
So we have 18 exhibits in your list. How will we know which exhibit number you're referring to?
There's actually, should be a divider between each exhibit as well with an exhibit number. And I believe this notice of intent, if I remember right, had the Bates ranges for each exhibit as well.
Mine doesn't. That's why I asked.
Okay. I'm not sure why that didn't get numbered, but we'll look into that.
Okay, no worry. Would you like to begin your case in chief with a opening argument?
Yes, Mr. Hearing Officer. Since this is Lewis Rose again, and with me is my witness, Steve Jetter with Glorietta Geoscience. I have a brief opening statement. Since, Mr. Hearing Officer, you've basically explained what the content of the petition is, I just want to remind the commissioners what statute and regulatory provisions apply, and then call my witness. Mr. Hearing Officer, members of the commission, this variance request is controlled by the Water Quality Act at section 74-6-4H. And what it says is the commission may grant an individual variance from any regulation of the commission whenever it's found that compliance with the regulation will impose an unreasonable burden upon any lawful business, occupation, or activity. And that's the focus of this hearing, as to what the burden of compliance with the dairy rules, particularly the closure requirements for impoundments, that would create an unreasonable, our position is that would create an unreasonable burden on Ironhorse, and you'll hear from Mr. Jetter as to why. I also point to the commissioners to the regulations at 20.6.2.1210, which is the commission's variance regulations that spells out the content of what needs to be in a petition and how the petition shall be processed. And what the regulation says at 1210C is that the commission may grant the requested variance in whole or in part, may grant the variance subject to conditions, or may deny the variance. So those are the relevant provisions in the rules governing the proposed variance petition. And Mr. Hearing Officer, we believe that after hearing the testimony, that the commission should grant the variance on the grounds specified. So, Mr. Hearing Officer, I'd like to call my first and only witness, hopefully, Mr. Jetter, and have him sworn at this time.
Ms. Dubois?
Mr. Jenner, I need to have you raise your right hand to be sworn in, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Jetter, could you state your name for the record, please?
Stephen Jetter.
And could you give the commission a brief description of your educational and work background?
I have about 30 years of experience as an environmental geologist. I obtained my bachelor's degree in geological sciences from New Mexico State University in 1987. I've worked for Glorietta Geosciences for the past 15 months, primarily doing dairy permitting, dairy corrective actions, and abatement. Prior to my work at Glorietta, I worked for 25 plus years with the New Mexico Environment Department. Eight of those years was with the Underground Storage Tank Bureau. I spent 4 years with the Hazardous Waste Bureau, and then I spent 13 years in the Superfund section, which is part of the Groundwater Quality Bureau. I do want to emphasize that during my time with the Environment Department, I did not work on any dairy permits, dairy facilities, or do groundwater discharge permitting.
Mr. Jetter, did you prepare pre-filed written direct testimony in this matter?
Yes, I did.
And do you have any corrections or additions to your testimony?
There is one addition, and it's regarding the replacement cost for the lagoons. We did obtain a verbal estimate from a contractor that does lagoon construction, and that's pretty much the only additional information that I have to submit.
Do you adopt your written direct testimony as your testimony in this proceeding?
Yes.
Mr. Hearing Officer, we have a PowerPoint presentation, which is one of our exhibits that Mr. Jetter is going to use in his summary. And I guess now I can share the screen. I can figure out how to do this.
And Mr. Rose?
Yes.
While you're setting up your presentation, my apologies. I did find where you marked each of your exhibits. It's in the middle of the page for any commissioner who's looking for an exhibit number. It's not on top or on bottom. It's in the middle.
Thank you, Mr. Hearing Officer. If I can figure out how to do this. Let's see here.
Pam, are you able to help?
Mr. Rose, at the bottom of the screen, there's a box with an arrow pointing up that says share content.
Okay, got that. That shows you old people trying to use this stuff can be frightening. Now I don't. Looks like the share is off. There it comes again.
Are you on?
I'm on. Let's see if we start maybe. Okay. Let's try start. Nope, that's not it. Here we come. The PowerPoint is loading. There we go. Mr. Jetter, could you summarize your written direct testimony? And you could refer to the PowerPoint presentation. As I said, Mr. Hearing Officer, this presentation is an exhibit to our written direct testimony.
Yes, it's Exhibit 4. It begins on page 28 of my direct testimony.
Thank you.
So what you'll hear from me is a summary of my direct testimony and how the closure will be conducted under an approved discharge permit overseen by the Environment Department. The requested variance is only a small part of the overall closure process.
You can't see it.
And granting the variance will be protective of groundwater and the environment.
Excuse me, Mr. Jetter. Mr. Hearing Officer, can you see the screen?
No, I just see where it says got it. Why don't you click on got it?
Okay, let's see. I don't see where it says got it, so.
I just see a gray screen, sir.
Okay, that's why I wanted to. Let's see.
Mr. Hearing Officer, this is Commissioner Hutchinson.
Yes, sir.
If commissioners or parties would go to his direct testimony, I believe his presentation, PowerPoint presentation starts at IBP 0029 under Exhibit 4.
I do see that.
I did.
Or no, go down a little bit and to the right.
Oh.
Yeah.
There you go, Mr. I needed expert assistance here. You can continue, Mr. Jetter. You want me to change? Tell me when you want.
Yeah, you can change. So a little background on the company and the people involved. Ironhorse Permian Basin, they're a New Mexico-owned small business that started in 2013. The company bought the former Lakeside Dairy property in 2014. They built out a rail yard terminal in 2014, 2015. The terminal provides loading and offloading of commercial materials and also rail car storage. They also provide commercial water sales through a sister company, Ironhorse Water Producers. Again, I work for Glorieta Geoscience. They're a New Mexico-owned small business that started in 1979. We primarily do water resource, water rights, environmental, and agronomy consulting services. We do permitting and compliance for over 35 dairies in several states, and we've been involved with either the former dairies at the property along with Ironhorse since about 2005. And we've already gone over my education. This is a figure that shows the site and the area. Artesia is up in the upper left-hand corner. Ironhorse is located about 5 miles south of Artesia. And the Pecos River is located about 3 miles east of the Ironhorse property. Next. So this picture on the right, well, if you're looking at my PowerPoint, I guess you don't need to know the exhibit number, but it is Exhibit 5, found on page 42 of my direct testimony. There were 2 dairies at the property from 1991 to 2013. The dairies were permitted to discharge 90,000 gallons per day to 4 land application areas, totaling about 360 acres. The Lakeside Dairy constructed an existing synthetically lined combination stormwater wastewater lagoon in 2011 and early 2012. However, shortly after its completion, the dairy closed. They removed all the cows and ceased wastewater discharges in August 2013. And on this map, you can see that these are the lagoons that we're talking about. This is the former milking parlor at the dairies. They were surrounded by the corrals. There's 4 land application areas, the north field, east-west fields, a south field, and a tourist pivot in the south. There's also a commodities storage area on the west side of the property here. In addition, there was an old wastewater lagoon just on the west side where the arrow is pointing. There was also a stormwater lagoon where the current lagoon system exists. So Lakeside purchased the property in 2014. They've constructed the rail terminal. It includes 45,000 feet of track. There's the north loop in the corral area, south loop in the tourist field. And then they repurposed the dairy lagoon, as was stated, for commercial water sales and for stormwater capture and retention. In April 2018, after consultation with NMED, they submitted a letter to the state with the intent to obtain a closure discharge permit. The permit application was submitted in December 2018, and NMED issued the discharge permit in 2020, August of 2020. The permit requires closure of the existing dairy infrastructures, removal of all manure solids, and a groundwater monitoring program.
excuse me for a minute, Mr. Hearing Officer, just like to point out that the permit, I believe, is part of the record in this proceeding. I think it was attached to our notice of intent, and I believe the department did as well. So the current permit should be in the record.
Thank you, Mr. Rose.
So this figure on the right is Exhibit 8. It's on page 46 of my testimony. The wells that are on here are monitoring wells from the dairy operations. All of those wells were abandoned back in 2016. However, under the new dairy permit, 2 new wells were installed. They were MW6R. And then there's an MW10 kind of by the east-west fields. On this map, it's labeled as MW12. However, NMED in the permit labeled it as a replacement well for MW10. And it's located kind of in between those 2 wells on the map. The body of water affected by this variance is the shallow alluvial aquifer. It extends from approximately 50 feet to 260 feet below ground surface. It's stratigraphically above the regional artesian aquifer. The lithology beneath the site consists of interbedded fine to coarse sands, silts, clays, and gravels. Depth to water historically was about 55 feet. It's currently at 68 feet. Groundwater flow direction is to the east towards the Pecos River. It's a gradient of 0.018 feet per feet. Again, there's no surface water on the site. The Pecos River is located 3 miles to the east. As far as background water quality, the numbers come out of MW8. Total dissolved solids are 830 milligrams per liter. There is no nitrate detected in the background water. Chloride is less than 25 milligrams per liter, and sulfate was measured at between 1,900 and 2,500 milligrams per liter in that well. So, as has gone over a little bit, Ironhorse is requesting the variance from compliance with the dairy rule at 20.6.630 A1 subparagraph C, E, and F, which govern closure requirements for wastewater, stormwater impoundments associated with dairy operations. And these requirements are also memorialized in the discharge permit, which states the permittee shall permanently close all impoundments, ponds, settling basements at the former dairy facility as identified and in accordance with 20.6.6 of NEMAC and in Table 1B or B1. Paragraph C requires that the wastewater, stormwater impoundments be emptied within 1 year. Paragraph E requires the removal of all the manure solids from the impoundments, and paragraph F requires that the impoundment liners be perforated or removed, and that the impoundments be backfilled with clean fill and regraded so it prevents ponding. That again is within 2 years. I do want to say on that, regarding paragraph E, that it appears that this requirement is partly related to the requirements in subpart F, in that solids would need to be removed properly and properly disposed of prior to the removal of the liner. And again, through this variance request, Ironhorse is requesting that we retain the synthetically lined combination greenwater, stormwater lagoon infrastructure associated with the closed dairy. The reason for this is Ironhorse has repurposed and integrated the lagoon system for use as part of the railroad terminal operations. They store artesian groundwater for commercial sales, and it also collects stormwater runoff for control and retention. The figure here is Exhibit 12 of my testimony on page 77, obviously also included in this PowerPoint. But again, the lagoon system, it's an integral part of Ironhorse for their stormwater control. They purposely designed, engineered, and developed the rail terminal, the track layout, in order to direct the site drainage to the impoundments for stormwater control. This infrastructure included over 20,000 feet of ditches and culverts, and it prevents damage to the tracks and track switching facilities. In addition, it prevents on-site runoff from flooding the neighbors' properties and farm fields. Again, the lagoon system was constructed in late 2011, early 2012. It's composed of 2 settling cells and 1 large holding cell. The total capacity is 52 acres. The cells are synthetically lined with a high-density polyethylene liner, and the cost to construct it in 2011 was about $460,000. This is a picture of the large lagoon. You can see the lining. Next. Back one. This is a picture of the 2 settling ponds. The one in the distance on the left is the primary settling cell. That's where the stormwater enters the system. It then flows through this pipe into the secondary settling lagoon, and then it flows out the back into the large lagoon cell. If you look at this this lagoon here, you can see that there's hardly any buildup of manure solids on the sides of this lagoon. So the WQCC regulations are implemented to protect both the Vado zone and groundwater from contamination. It's our position that the continued use of the lagoon will meet these regulatory and statutory requirements for protection of groundwater through a monitoring of the former lagoon, and also for the following reasons. The lagoons are synthetically lined, and they were used for only about 18 months. Therefore, there's only a limited amount of dairy waste that ever comes through the lagoon, and only a amount of solids that exist. The nitrate sources have been removed through termination of the dairy's wastewater discharge, and the fact that the cows were removed. The corrals were scraped of manure solids at the time of closure. There's no nitrate contaminant runoff occurring at the facility. And unfortunately, this didn't make it into the slide, but if you refer to Exhibit 6 on page 43 of my testimony, this is a Google Earth image from 2014, roughly a year after termination of the dairy operations. And the photo indicates that the corral areas were scraped of the manure solids. In addition to that, Ironhorse will operate under a closure plan that requires that a physical survey of the former corrals be performed. That survey will identify if any remaining manure solids are in the corrals, and if so, they will be removed and disposed of properly. Again, only fresh groundwater will be stored in the lagoon. The water quality of that artesian well is similar to the background water quality. It's a little bit elevated in TDS, but the others are below what is in the background in the background well. There's also a groundwater monitoring program. There's a groundwater monitoring well, MW6R, which is located immediately down gradient of the lagoon system. So in regards to compliance with the regulations and representative of an unreasonable burden to our client, Ironhorse would need to replace the perfectly functioning lagoon system. The lagoon's only accepting water that meets Wqcc standards, or groundwater that is, or surface runoff that is not impacted by contamination. Again, the lagoon costs were around $460,000 in 2011. We did get a verbal quote from a company that does these lagoon installations in southeast New Mexico. Their current estimate for a similar sized lagoon is around $900,000 to $1 million to replace it today. There's also a significant cost just in the design and incorporation of the rail terminal facilities stormwater drainage system. Additional cost would be incurred to remove and replace the lagoon. And based on the current site drainage, the replacement lagoon would have to be sited at the same location. Again, the system also controls runoff to the adjacent properties, and no contamination will result from its continued use. So in closing, I would just like to say that I want to reiterate that Ironhorse will be operating under an NMED-approved discharge permit. It includes an inspection of the corrals and a continued monitoring of both the lagoon and the groundwater during the term of the permit. And the variance is only part of the overall closure process. This concludes my testimony.
Mr. Jetter, just do you have anything else to add in terms of your direct testimony?
Not at this time.
Mr. Hearing Officer, that's all my questions with Mr. Jetter. He's now for cross-examination.
Thank you, Mr. Rose. Let's pause for a moment. Commissioners, I'd like to direct your attention to 20.1.3, subsection 17, subsection H. It is the burden of persuasion during this hearing, and it reads as such. At the hearing, the petitioner has the burden of going forward with the evidence and of proving by a preponderance of the evidence the facts relied upon to justify the relief sought in the petition. Following the establishment of a prima facie case by the petitioner, any person opposed to the relief sought in the petition has the burden of going forward with any adverse evidence and showing why the relief should not be granted. Okay. So, Mr. Rose, your witness is standing for cross-examination at this point, you said?
That's correct.
Does the department have any cross-examination, Mr. Atencio?
Thank you, Mr. Hearing Officer. We have no questions for Mr. Jetter.
Okay. Do any of the commissioners have any questions?
Mr. Hearing Officer, this is Commissioner Hutchinson.
Yes, sir.
Mr. Jetter, I'm aware that there have been some fairly heavy storm systems that have gone through the area. Would you describe the performance of your system, and if indicated, did it adequately capture the rainfall events in the recent month?
Well, I have not talked to Ironhorse. I haven't got any indication from Ironhorse that the ponds have not been functioning during these recent storms. I know it was designed to handle a 24-hour, basically a 100-year flood event. It is designed to be able to handle that capacity.
Thank you, Mr. Hearing Officer.
Are there any additional questions from any of the commissioners? Okay, not hearing any. Are there any questions from the general public? Okay, not hearing any. Do you have any other witnesses you want to call, Mr. Rose?
No, Mr. Hearing Officer, that completes our presentation.
Okay, so you rest your case in chief?
That's correct.
Okay, department, Mr. Atencio?
Thank you, Mr. Hearing Officer. I just have a brief statement and just a couple questions for our direct witness, Ms. Sarah Schnell. So I'll go ahead and get started with that. Thank you for your time this morning, for listening to both the petitioner and the department in this matter. With me are Ms. Sarah Schnell and Nancy McDuffie of the department's Groundwater Quality Bureau. In just a couple of moments, Ms. Schnell will provide a direct testimony as to the department's support for the variance petition. Ms. McDuffie will be available for policy and bureau-wide questions. Generally, the department supports the variance petition filed by Ironhorse because compliance with the applicable provisions as described in the variance petitions and further described this morning by Mr. Jetter would be an unreasonable burden on the facility owner. And you mentioned earlier, Mr. Hearing Officer, of impaneling the witnesses to answer any kind of cross-exam questions, and the department would like to take advantage of that opportunity later on.
So noted.
All right, Ms. Schnell, are you on and available?
Good morning. Yes, I am.
So Ms. Schnell, you're going to be sworn in by the court reporter?
All right. Allow me to start my video.
Yes, please.
There we go.
Ms. Schnell, would you please raise your right hand to be sworn in? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down.
Please proceed.
Thank you. Would you please state your name for the record?
My name is Sarah Schnell.
Could you briefly describe your educational background?
I hold an Associate of Applied Sciences from Paul Smith's College of New York for Ecology and Environmental Technology, and a Bachelor of General Studies from New Mexico Tech in Socorro.
Who is your current employer?
I'm currently employed by the New Mexico Environment Department's Groundwater Quality Bureau.
And what is your position at the Groundwater Quality Bureau?
I am a geoscientist with the Agriculture Compliance Section.
What do your duties usually consist of in that position?
In that position, my primary duties are as a permit writer, site inspector for dairy, chili, cheese, and other industrial wastewater producing facilities.
Ms. Schnell, did you pre-file your resume in this matter?
Yes, I did.
And did you pre-file written technical testimony?
Yes, I have.
Could you please briefly summarize your pre-filed testimony?
Sure. The petitioner intends to beneficially reuse synthetically lined stormwater and wastewater impoundments that currently exist on a former dairy site, which is no longer in operation. Prescriptive closure of the former dairy facility, pursuant to 20.6.6.30, subsection A1, C, E, and F of the New Mexico Administrative Code, would require the removal of the synthetic liner and backfilling of the existing impoundment. The petitioner is requesting a variance to this requirement on the grounds that compliance with this requirement would cause an unreasonable burden and that the proposed future use of the impoundments is protective of groundwater quality. The petitioner proposes to beneficially reuse the existing impoundments for continued site stormwater control and to store pumped groundwater. These proposed activities do not pose an inherent threat to the groundwater quality. Groundwater quality samples collected from the impoundments and from an on-site supply well are consistent with site and regional groundwater quality data. Based on groundwater quality data for the site and the region, and the proposed future use of the impoundments, Groundwater Quality Bureau recommends the approval of this variance for the life of the feature.
Thank you. Do you have any changes to make to your pre-filed testimony?
No, I do not.
Do you adopt your pre-filed testimony in this matter?
Yes, I do.
Thank you, Ms. Schnell. Mr. Hearing Officer, I think we already had covered moving our exhibits into the record, so we have no further direct questions for Ms. Schnell and would make her available and then Ms. McDuffie for cross-exam and any questions from the public or commission.
Okay, let's start with cross-examination questions by the petitioner. Mr. Rose.
Mr. Hearing Officer, I have no questions of this witness.
Thank you, sir. And from the commissioners?
Mr. Hearing Officer, Commissioner Hutchinson.
Yes, sir.
Ms. Schnell, you heard my previous question for the petitioner. Are you aware of any site visitation or observation of the site following the recent storm events?
I'm not aware of any.
Okay. With that, Mr. Hearing Officer, that's all that I have. Thank you.
Thank you, sir. Are there any other questions from commissioners?
Mr. Hearing Officer Larry Dominguez.
Yes, Mr. Dominguez.
Thank you, Mr. Hearing Officer. Ms. Schnell, help me with kind of a process question with the Discharge Permit 796. So this is a variance for the closure permit. In essence, so that the lagoon does not have to be deconstructed and cleared off. So if that variance is approved, will there still be a discharge permit in place? Or once the closure of 796 has been completed, then that will dispose of DP 796. Help me with the process with the closure permit and where things move forward, assuming approval of the variance.
If I may, I'd like to defer to my supervisor, Nancy McDuffie, for this matter.
We don't have Ms. McDuffie sworn in yet. Mr. Atencio?
Thank you, Mr. Hearing Officer, for noting that yes, Ms. McDuffie and her resume were provided as potential policy witness, and then again her resume and the department statement of intents, and we'd offer statement of intent to present technical testimony, and we would offer her as a policy witness for this panel.
So let me just make sure I understand what you're saying. Let me go to your, let me go back to your pre-filed and look at the exhibits. Yes, we have resume exhibit 3. And do we have anything else for Ms. McDuffie besides exhibit 3?
No, she is presented solely to respond to questions that may exceed the scope of Ms. Schnell's position as geoscientist and pertain more to policy or bureau-wide questions.
So, Ms. Dubois, would you swear in this witness? Thank you.
Ms. McDuffie, I need to have you raise your right hand to be sworn in, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please proceed.
So this discharge permit, the normal discharge permit term is 5 years from date of issuance. So this permit would expire 5 years from, well, yeah, on August 27, 2025. The former dairy had groundwater contamination present at the time of closure or prior to closure at the last monitoring data that was submitted to the department in 2012. And so a permit for post-closure could be issued if the groundwater contamination is not below the standards of 3103. And so another 5-year permit could be issued if the groundwater doesn't meet those standards at that time of expiration. And the permits will continue to be issued until groundwater quality meets the standards or background.
Okay, thank you, Ms. McDuffie. Follow-up question. So 796 will continue to be in existence. Will it still be functioning under the dairy rule, even though this new facility is not a dairy?
Until the closure requirements by the dairy rule are completed, it would continue to be under a closure permit under the dairy rule.
Okay, thank you.
Does that conclude your questions, Mr. Dominguez?
At the moment, I'll defer to other commissioners and see if I have anything to come back to. Thank you.
I think Mr. Thompson had a question.
Yes, I do. This is Commissioner Thompson.
Please proceed.
This follows along the lines of the questions from Commissioner Hutchinson, and it's not clear to me, will the pond used for stormwater capture also be used for storage of fresh water for subsequent sale?
And who are you asking that question to, sir?
I'm sorry, I'm asking that of Ms. Schnell.
Thank you.
Sir, I believe that is the case, but I'm not entirely sure. I would recommend speaking to Ironhorse representatives about that one.
I'm not sure how to procedurally go back to Ironhorse. They have rested their case. They may put on a rebuttal case if they so choose, and I'll leave that to Mr. Rose to decide if he wants to do that, and that may answer your question, Mr. Thompson.
Thank you.
You're welcome. Are there any other commissioners with questions for this panel? Well, I have a question, and of course, I'm just a novice. So, but to clarify what's going on here, how long does this variance go on, and what happens when the variance goes away? And anyone can answer that from the panel. Does anyone have an answer?
I can answer. The variance can be granted by the commission for the lifetime of the feature. And if that is the case, then the petitioner would give a 5-year review report to the department every 5 years to verify its use and continued use and structural integrity. And then the department could reapprove or propose to have it disapproved, I guess. Is that correct, Mr. Atencio?
Well, he's not answering questions, so we can't ask Mr. Atencio.
Sorry.
You're the witness, Ms. McDuffie. as is Ms. Schnell. But my question really goes to, okay, so the variance can go on, it sounds like indefinitely with check-ins. What happens when this Ironhorse company, LLC, decides that they want to dissolve or sell or stop using it for freshwater sales? What happens at the end?
Then depending on the new use, or if there was going to be a new proposed use, that could either be, probably would have to have a new petition for proposed new use, or it could be perforated and backfilled.
Is the variance assignable if Ironhorse sells to someone else? Can they transfer this variance to the new owner?
The permit can be transferred to a new owner, and I assume if the variance is tied to the permit, then it would go with it, yes.
Okay, I have no further questions for these witnesses. Are there any other questions from the public or from commissioners that these questions might have brought up?
Mr. Hearing Officer Larry Dominguez.
Yes, sir.
A follow-up question from your question, just to help clarify the long-term aspects. So, Ms. McDuffie, if Ironhorse was to go out of business or whatever, then a closure permit would have to proceed for that permit, which, regarding the variance, if a closure permit is fully activated, then that lagoon would be closed out. It wouldn't just continue to exist there. It would fall back to the closure permit. Is that correct?
Yes, that's correct.
Okay. Thank you, Ms. McDuffie.
Hearing Officer Shkalin.
Who's speaking now?
The Mission Counsel Sanchez, if I may speak.
Do you want to have a private discussion?
No, I don't think so. I just wanted to refer to a particular administrative rule that may be responsive to the questions that are being raised by Commissioner Dominguez.
Okay, please.
I would refer the commission to 20.6.210 subsection C, and that reads, the commission may grant the requested variance in whole or in part, may grant the variance subject to conditions, or may deny the variance. And then it has, if you will, some variables. If the variance is granted in whole or in part, it provides essentially for conditions being attached to that grant of variance, and also requires or provides for the commission specifying the length of time that the variance will be in place. I just wanted to point out that particular administrative rule and thought that it might be helpful to the questions that are being posed by the commission. Thank you.
Thank you, Mr. Sanchez. Does the department have any further witnesses it wants to call?
No, Mr. Hearing Officer, no further witnesses.
And Mr. Atencio, thanks, Mr. Atencio. Just to be clear, is the department recommending granting the variance outright, or are there any conditions along with granting it in the department's position?
Mr. Hearing Officer, I think pursuant to the statement of intent that the department pre-filed and Ms. Schnell's testimony in that, the recommendation was from the Bureau to grant the variance as proposed in the petition.
Okay, thank you. We're going on to rebuttal evidence now. Mr. Rose, do you have a rebuttal case?
Mr. Hearing Officer, no, but we're willing to put Mr. Jetter back on in response to Commissioner Thompson's question, if that's appropriate. And one additional thing, we did check with the client in response to questions about the performance of the ponds during the recent rain events. And it's our understanding that the ponds worked according to design, and there was no spills or discharges from those ponds as a result of these events. So just wanted to update the commissioners on that. And Mr. Hearing Officer, I said if Commissioner Thompson still has a question, we're willing to have Mr. Jetter available to answer it.
Well, I think, Mr. Rose, that two things. Number one, your statement about the pond's performance in the rainstorms is not evidence, as you know, it's argument. However, it seems to me that your witness, Mr. Jetter, would be helpful for him to answer the questions that were posed earlier, and I do believe it would be within the definition of a rebuttal case in that it was a surprise. You couldn't have anticipated that question, and so I'm going to recall that witness, Mr. Jetter, and ask the commissioner who asked that question to ask it to Mr. Jetter.
Okay, this is Commissioner Thompson, and my question is, are the ponds that receive stormwater also used to store fresh water for subsequent sale or use by Ironhorse Permian Basin?
Yes, they are. They're used for both.
Does that conclude your question, Mr. Thompson?
That does. Thank you very much.
Okay. Are there any other questions for this witness from any of the commissioners?
Mr. Hearing Officer, this is Commissioner Timmons.
Hello. Please proceed.
I am not sure this is the right place to ask this question, but I'm curious, I think, for Mr. Jetter, if there is any anticipation of periods of time when these lagoons will be dry, or if it is anticipated that they will always be maintained with water in them as part of the lifetime of the lagoons.
Mr. Jetter, that seems like an appropriate question.
Yeah, so to maintain the integrity of the liner so they don't get deteriorated with UV rays from the sun, and to prevent just damage in general, there is a certain amount of water that would be maintained in the lagoons.
Okay, thank you.
Thank you, Ms. Timmons. Are there any other questions for this witness on rebuttal? Any from the public? Okay, not hearing any further questions. Mr. Rose, does that rest your rebuttal case?
Yes, it does, Mr. Hearing Officer.
Okay, and Mr. Atencio, do you have a rebuttal case?
No, Mr. Hearing Officer.
Okay, then I believe that the evidentiary part of this hearing is concluded. So let's go to the next phase of this. All right. I would like to thank the board or the commission and everyone present for their participation today. A quorum of the board of the commission members have attended, and the hearing notice indicated that a decision might be made at the conclusion of this hearing. The board may immediately deliberate and decide on the proposed variance petition and come back and announce their decision. The commission may also direct the hearing officer to develop a hearing officer's report. Would the commission like to advise how they want to proceed?
Does any commissioner have an opinion as to whether we should enter into deliberations immediately? There's also the opportunity to enter into executive session if that's wanted, or if we should request the hearing examiner prepare a report.
Mr. Chairman, this is Commissioner Hutchinson. I don't think that we need to go into executive session, that we can deliberate in open session and reach a decision. So that's my recommendation, that we proceed forward with deliberation and decision.
Thank you, Commissioner Hutchinson. I would tend to agree. Does anyone else have an opinion?
Mr. Chair or Vice Chair, Commissioner Dominguez, I would concur with both yours and Commissioner Hutchinson's thoughts on that, as well as I would add that I do not believe there's a need for a hearing officer's report. That typically would be done for the commission to utilize in its decision-making process. I think the record as it stands has been well developed by both parties, and that there's enough information there for the commission to deliberate off of.
Thank you, Commissioner Dominguez. Again, I would agree. Is there any commissioner who does not agree? Okay, hearing none, we can enter into deliberation. Do people want to enter into deliberation immediately, or would people like a break for 10 minutes?
Mr. Vice Chair?
Yes, Commissioner Cipher.
Yes, I was just curious, did you want the next step? In other words, if we would like to deliberate now, would you like that to be by motion, or can we just begin deliberations?
I don't believe, thank you. I don't believe we need a roll call vote to enter into deliberations, but Mr. Sanchez or Ms. Jones or any commissioners, you could correct me if I'm wrong. No, I think we can just enter into deliberations.
Okay, great. So I would also say a 5-minute break would be nice at this time.
Okay, let's take a 5-minute break. Come back. It's 10:29 right now, so let's just come back at 10:35. Thank you. I see people's cameras coming on. We'll give it another minute or so. Miss Jones, when we take a break and come back, do we need to do another roll call to ensure that everyone's back? How does that usually work?
I would think we would.
Okay.
Mr. Sanchez might have something different to say, but I think we should do that to make sure we have quorum.
Okay. Yeah. Mr. Dominguez says
Pam,
yes.
Pam, this is Robert, Vice Chair Wade. Yes, we would like, you should go ahead and have a roll call to make sure we have a quorum, if nothing else.
Thank you. Miss Jones, would you call
Thanks,
roll?
Council. Yes, I will. Calling Commissioner Candelaria, who is absent. Commissioner Surton.
I'm here.
Thank you. Commissioner Dominguez.
Present.
Commissioner Hutchinson.
Here.
Commissioner McWilliams.
I'm here.
Commissioner Musharafi. Commissioner Musharafi, have you rejoined us?
I'm here.
Thank you. Commissioner Modi. Commissioner Modi. Move on. Commissioner Patton.
Here.
Thank you. Commissioner Rader.
Here.
Commissioner Cipher. Commissioner Cipher, have you rejoined? Commissioner Thompson.
I'm here.
Commissioner Timmons.
I'm here.
Vice Chair Wade.
Here.
Chair Stringer.
Present.
Let me go back to Commissioner Modi. Have you rejoined us? And has Commissioner Cipher rejoined?
Yes, I have rejoined.
Very good, thank you. And one more time, Commissioner Modi, have you rejoined? Okay, Vice Chair Wade, you have a quorum. You have 2 commissioners absent.
Thank you. Okay, commissioners, now we have come to the portion where we may deliberate on the variance request made by Ironhorse. Is there anybody who would like to lead this? Mr. Commissioner Dominguez, please.
Mr. Vice Chair, just to lay some foundation, I thought some opening comments might help frame things for the commission. And since I was around for both iterations of the dairy rule process and the fond memories that follow that, I think what we're dealing with here is a little bit of a unique situation. I think when the commission actually approved the dairy rule, this is one of those situations that was really not fully anticipated when doing the dairy rule. It was hard to actually think about, okay, a dairy going out and then being rebought and somebody wanting to repurpose a perfectly good lagoon. I don't think that ever was even a vision during the dairy rulemaking process. But with that said, I think that actually shows part of what the provisions for the variance provision that's in there, why that variance provision's there to address unique situations. And I think that's somewhat what's before us is a unique situation. Typically, this commission, when dealing with variances, it has been a little bit different than this situation. This one being unique from the standpoint that we have a perfectly good lagoon and it's wanting to be reutilized for a beneficial use. I think this makes this, in my perspective, a little more of a clear-cut situation. So I'm hoping that helps frame things and move along the deliberations. And at any point in time, I would be willing to offer a motion once we've had any other input. Thank you.
Thank you, Commissioner Dominguez. I'd like to note that Commissioner Modi, I believe, is present. Commissioner Modi, were you present at the beginning of the deliberations?
Yes, I was present.
Oh, thank you. So, Ms. Jones, if you'll mark that she has been present for deliberations.
Yes, sir. Yes, sir.
Well, I again agree with Commissioner Dominguez. I feel like the request is protective. It does put the lagoons to a beneficial reuse. I think that the chances of pollution are low. So I would agree that this is something the commission should consider granting. Commissioner Cipher, your camera came on. Did you have a comment?
Yes, Vice Chair Wade, I really think the presentation today has been simple and clear. And I really have no more deliberations to make except to agree with Commissioner Dominguez, and I'm certainly ready for a motion if there's no other questions by my companions.
Any other commissioners? Comment? I'm hearing none. Mr. Dominguez, would you like to make a motion?
Yes, thank you, Vice Chair Wade. I would make a motion to approve the variance as requested.
And do I hear a second?
This
I
is
second.
Hutchinson. I will second.
We got 2 seconds. So,
okay.
Okay. Ms. Jones, would you like to call a roll vote?
Yes, I actually, and just to be clear, I have Commissioner Hutchinson as seconding that motion. I wasn't sure who the other voice was coming through.
Okay.
So starting with Commissioner Candelaria, who is absent. Commissioner Surton, how do you vote?
Yes.
And Commissioner Dominguez.
Yes.
And Commissioner Hutchinson.
Yes.
Commissioner McWilliams.
Yes.
Commissioner Musharrafi.
Yes.
Commissioner Modi.
Yes.
Commissioner Patton.
Yes.
Commissioner Rader.
Yes.
Commissioner Cipher.
Yes.
Commissioner Thompson.
Yes.
Commissioner Timmons.
Yes.
Vice Chair Wade.
Yes.
Chair Stringer.
Yes.
Vice Chair Wade, the motion passes with 1 commissioner absent.
Thank you.
Mr. Vice Chair Wade, this is Commissioner Hutchinson.
Yes.
I was just wondering about preparation of the order. I think, I'm not sure which our new chair or yourself would be signing the order, and we need to have someone prepare it.
Thank you, Commissioner Hutchinson.
Vice Chair Wade?
Yes, Mr.
Vice
Sanchez.
Chair Wade? Mr. Commissioner Hutchinson anticipated my comments. I believe that since you presided over the proceeding, you should sign the order and statement of reasons. And looking at 20.1.321 subsection D, I would ask the chair to request or direct Mr. Rose to prepare a proposed order and statement of reasons.
Thank you, Mr. Sanchez. Mr. Rose, are you present?
Mr. Chair, we can certainly prepare one. I would suggest, though, that if I draft a proposed order, I'll also send it to Mr. Atencio for review and approval before we submit it to Mr. Sanchez for his review.
I think that would
be fine.
Yes, we would appreciate that. Thank you.
Thank you, Mr. Chair.
Any other thoughts on this matter? Mr. Chakalian, your camera just came on. Did you have anything on this matter?
No, sir. I was preparing to proceed with the next matter when you tell me to start.
All right. We will start on the next matter, which is on the agenda, item number 8, Wqcc 2104. And this is the matter of...
Mr. Vice Chair, this is Commissioner Hutchinson.
Yes.
And Mr. Chakalian, did we actually close out the record?
We did, sir. Before you deliberated, I announced that the hearing had come to an end. The evidentiary hearing had come to an end.
Okay. I was on a phone call, so I might have missed that. Thank you.
Thank you, sir.
If we're ready, we can go ahead and proceed on Wqcc 2104, which is the Vision Mobile Home Park.
Okay, thank you, Vice Chair Wade. I'm not going to read a lot of what I've already read. Everyone was present for most of what I've already read. This is a little different matter. This is a compliance order hearing where we have a complainant and where we have a respondent. That is a little different than a petitioner and the department just responding. So in a compliance order hearing, there was a compliance order. It was filed with the petitioner, with the respondent. The respondent's name is Maricela Ornelas. Are you present, Ms. Ornelas? She was present earlier. It said something number 3, phone call number 3. Okay, I don't see her present. So we'll get to that in just a moment. She did not actually file a initiating document in this case. It was filed by another man who I think you've met last month. His name is Charles Patton. He's not an attorney, but you don't need to be an attorney to represent someone in front of the commission. When he filed the initiating document in this case, it did not comply with the rule 20.1.3.19A2 because he did not attach a copy of the compliance order, and that delayed the docketing of this compliance order hearing with this commission. Finally, they did produce the compliance order, and we proceeded. And as the hearing officer that was appointed, I was privy to motions that were filed by counsel for the department who's with us, Christopher Vigil. And discovery did not proceed in the normal manner here. Mr. Vigil, according to the rules, filed a witness list and an exhibit list. He then filed an amended exhibit list. And there are a few other exhibits that were filed last minute, which I've not looked at yet. But he did comply with the rules, and he served Ms. Ornelius and Mr. Patton with those documents. He also made a request for admissions. To try to simplify this hearing, he filed what we call a request for admissions. It's included in your packet because it is evidence. The rule states that if the other party does not respond and deny, then these admissions, these requests for admissions, become evidence. And that's why I included it in your packet through Pamela Jones. That document was filed on May 10, and the other party had a certain number of days to respond. They did not. There was then a motion to move this hearing into a whole different neighborhood. Instead of a compliance order hearing, this was going to become under rule number 21, that's 20.1.3.21. Excuse me, that's not the one. 22, I apologize. Alternative resolution summary procedures. Mr. Vigil, being attentive, decided, well, if the other party is not going to present any evidence, then I should make the decision to, admitting his evidence, find that a preponderance of evidence on the compliance order violations have been met, and we therefore then just expedite this hearing under 20.1.3.22A2. It's basically a summary procedure. I granted that in part. I granted that in part because I felt like he had a good point. It felt to me that Vision Mobile Home was not complying with the rules. They were not producing their exhibits. They were not producing a witness list. They were not cooperating. And I granted it in part by saying, Vision Mobile Home, I'm going to give you a period of time to file your exhibit list and your witness list. They didn't do that. That order was served on them through email, the email that they use on a regular basis to communicate with the hearing administrator, Pamela Jones. They did not do that. So at this point, I don't even know if the respondent is with us. I have no idea if the respondent is even here. Ms. Ornelius, are you with us? Ms. Jones, I see call-in user number 5. Could that be Ms. Ornelius?
If it is, they can. I will request them to unmute, and we'll see who they are.
Ms. Ornelius, I don't know if the commissioners noticed, but she made a comment, a public comment at the beginning of this hearing. I don't know if the commissioners remembered where she thanked the commissioners. It was the only public comment that was made. So she was here, and then when I was asking for entries of appearance, and Mr. Rose and Mr. Atencio entered their appearance, she also entered an appearance, although not for the proper case. As the hearing officer in this case, it is my power, and it's here in the rule. And I was reticent to do this when Mr. Atencio filed his motion asking for an expedited summary judgment, basically. Under 20.1.3.10, the powers and duties of the commission and the hearing officer, under B2, it talks about the functions of the hearing officer. It says that I shall conduct a fair and impartial proceeding, assure that the facts are fully elicited, and avoid delay. I also have authority to take all measures necessary for the maintenance of order and for the efficient, fair, and impartial adjudication of issues arising in proceedings governed by this part, including but not limited to rule on motions and procedural requests that do not seek final resolution of the proceeding and issue all necessary orders, issue subpoenas, which I did. About a week ago, Mr. Vigil filed a subpoena for documents. I did sign that. The respondent had 1 week to produce documents or to object to it. They did neither, as far as I know. I can also impose sanctions subject to review by the commission on parties who cause undue delay and fail to cooperate in the proceeding, and that is subsection BF. Now, I also saw Mr. Patton on the call this morning as well. I don't see Mr. Patton anymore. I'm going to ask again, is Ms. Ornelius with us? Now, I do see a K Patton here who's muted, and I'm not sure why. Mr. K Patton, are you with us?
Yes. Good morning, Mr. Hearing Officer. I am a commissioner, Kirk Patton.
Oh, excuse me, a different Patton. Thank you, sir.
Yes.
Thank you. Well, Commission, let me start here. This is an evidentiary hearing. We have evidence that has been filed correctly by the department. So far, we have no evidence from the respondent. I'm going to ask counsel for the department, do you have any motions to make at this time?
Thank you, Mr. Hearing Officer. This is Chris Vigil, the New Mexico Environment Department. Mr. Hearing Officer, respectfully, I had one other motion on the table as well. I think that written motion may be a better way to, rather than an oral motion, just a suggestion.
Please proceed.
Oh, yeah, I'm sorry. What I was referring to, I had a motion to issue a pre-hearing order, and maybe that's what we're doing now, which is okay, I think I know what's going on now. I'm sorry. Okay, I apologize. I would like to move that the answers be admitted as admissions, and that the hearing officer enter, I believe it is NMED Exhibit 22, into evidence. I apologize. I guess I was anticipating that you would deal with that in the beginning, and I see what you're doing. I'm sorry.
So noted. Let's start with any objections. Are there any objections to entering into evidence the request for admissions, which, by the way, the rule says they are admitted if they are not responded to and denied specifically. So do I hear any objections? Hearing none, they are admitted into evidence. Are we going to list this as an exhibit, sir?
Yes, I would like to enter this as Exhibit 22. And I would also like to move that all the exhibits 1 through 24 will be admitted.
Do I hear any objections? Hearing none, they're all admitted into evidence at this point. Would you like to make an opening statement?
Yes, I would. Thank you very much. Mr. Hearing Officer, Commissioners, the department is before you today on an administrative compliance order issued to the respondent on January 8, 2021 for violations of the term of a 2012 settlement agreement between respondent and the department, and for failing to adhere to the conditions of the discharge permit in this matter, DP 1691, Discharge Permit 1691. The purpose of this hearing is for the hearing officer and the Wqcc to determine whether violations 1 and 2 of the ACO are proven by a preponderance of the evidence. In preparation for this hearing, the department filed and served respondent with a request for admissions on the May 10th of this year in order to narrow the issues so that the hearing could focus on the actual contested issues. Respondent's answers were due no later than June 1st. However, respondent never responded to the request for admissions, and under the Wqcc adjudicatory rules, any requests not expressly answered are deemed admitted. Each request for admission addressed a certain factual allegation in the ACO, including every allegation necessary to prove violations 1 and 2 of the ACO by a preponderance of the evidence. Respondent's failure to respond to the request for admissions amounts to an admission to all of the factual allegations in the ACO, and there are no more issues in contention with regard to the violations. Therefore, the violations in the ACO are both proven by a preponderance of the evidence. Because the violations are proven by a preponderance of the evidence and further testimony is not necessary, the department will not be presenting direct testimony on the violations in the ACO. However, the department witnesses will sit as a panel to answer questions from the hearing officer and the commission on all aspects of the case, including the violations in the ACO. I want to make it clear that because of the admissions are deemed admitted, and because the ACO are proven, the Bureau will still sit for questions from the QCC on any issue in this case. But there is one last matter in controversy, and arguably it's the most important, and that's the large civil penalty in this matter. And the department will call Mr. Jason Herman, the pollution waste team leader in the pollution prevention section of the Groundwater Quality Bureau. Mr. Herman will give testimony on how the civil penalty was calculated, what the Bureau's rationale was, and the rest of the panel for cross-examination as well by the respondent, the hearing officer, and the commission. If it pleases the hearing officer and the commission, the department calls its first witness, Jason Herman. You're muted, Mr. Hearing Officer.
Thank you. I would like to, before you begin your case, Mr. Vigel, I want to caution the commissioners, since we don't have a respondent present, since we don't have any evidence submitted by the respondent, I want to bring your attention to subchapter J of 20.1.3.19, the hearing burden of persuasion. And Mr. Vigel, I caution you because if you elect just to rely on the exhibits that are in evidence, I just want to caution you. It says here, at compliance order hearing, the department has the burden of going forward with the evidence and of proving by a preponderance of evidence that the violation occurred and that the proposed civil penalty, revocation, or suspension, as the case may be, is appropriate. Following the establishment of a prima facie case, the respondent shall have the burden of going forward with any adverse evidence or defense to the allegations. So, Mr. Vigel, I wonder if it wouldn't be prudent to have each of your witnesses come on to the witness stand, be sworn in, adopt their testimony under oath, and maybe give us a minute or two of a summary, just so we have something in the record and not just the exhibits that were admitted. How do you feel about that?
We don't oppose that. We don't have direct testimony prepared, but I think what you're asking is if we just reverse the order of testimony and put the panel on first, and I think that's fine.
I'm not sure that that's what I said, so let me go back again. How many witnesses do you have on your panel?
We have 3 witnesses on the panel, one witness for direct testimony only on the issue of the fees, the penalties.
Okay. do you have any witnesses that can testify toward the violations in the compliance order?
Yeah, yes, we do. We do. We just don't have testimony prepared.
That's okay. Again, I'm asking for a several-minute summary. Hopefully they won't need to prepare for that. Would you please call your first witness, and let's first do a prima facie case that the violations actually occurred.
Okay, thank you very much. Mr. Hearing Officer, I think that procedurally, I think the prima facie case has already been made by the admissions. We're happy to move forward, but is it necessary?
I'm not debating that the prima facie case may be made by the exhibits, but if you want the commissioners to deliberate, and if any of them have not had a chance to review your exhibits carefully, you might want to give them a little foundation.
Oh, no, that's perfectly understood. Okay, now I understand. Great. And I think Mr. Herman can handle all this. So what we'll do is we'll walk through the documents and a little bit of the history of the case. But let me start with qualifying Mr. Herman. I think he needs to be sworn in.
Mr. what?
I think, is Mr. Herman been sworn in yet?
No.
Mr. Herman, I need to have you raise your right hand to be sworn in, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Mr. Herman, can you state your name and position for the record?
Sure. My name is Jason Herman. I am the Domestic Waste Team Leader for the Pollution Prevention Section in the Groundwater Quality Bureau.
And can you describe the duties associated with your position?
Sure. I manage a permitting staff of permit writers. The permits are issued for discharges of domestic waste that may affect groundwater. Permits are issued through the 20.6.2.3 thousand NMAC regulations. This includes more than 250 domestic waste sites in New Mexico, which range in size from small quantity discharges of less than 10,000 gallons all the way up to larger multiple million gallons per day systems. My management of domestic sites includes making decisions regarding permitting actions, the permitting requirements for those sites, enforcement actions, and also prioritization for staff's attention. I also oversee a caseload of around 25 permits of my own. My caseload usually is propagated with sites that require special attention or particularly controversial sites due to their histories or the nature of their facility operations.
And how long have you been in your current position?
I have been team lead for 2 years and 2 months.
And would you please give us a brief overview of the relevant educational background and training, your relevant educational background and training?
I have a bachelor's degree in environmental planning and design and a master's degree in water resources management and a second master's degree in community and regional planning. I was a permit writer for the pollution prevention section for 2 years before becoming team lead. And I've attended multiple third-party trainings through the Environment Department on gaining voluntary compliance and environmental compliance. And I've also led successful compliance and enforcement actions for dozens of sites during my time, both as a permit writer and as a team lead.
And approximately how many groundwater administrative compliance orders have you been involved with?
So I have been involved with 3 total compliance orders of different varying sites, but ACOs are pretty rare for groundwater quality bureau enforcement actions, and it's sometimes not really easy to get opportunity with them for experience with them.
Okay, great. Mr. Herman, we're going to go through a few documents here. I know we haven't prepared, but you're very with these, I'm sure. Ms. Jones, is there a way I can share a screen so that the commissioners and Mr. Herman and the hearing officer can see the documents that we're going to be going through? And this will not be an exhaustive all-day thing. I just want to let everyone know. I think we will be concise, but it is important to lay a foundation.
Yes, Mr. Behill, you have the ability to share your screen.
Okay, thank you. Now, I'm not sure. Let me see here. Can everyone see this document, the stipulated final order?
Yes.
Okay. Mr. Herman, this is not the stipulated final order. Can you read? Have you seen this document before?
Yes, that's the administrative compliance order.
Oh, great. And let's see here. Let's take a look at the date at the bottom. When was this document signed?
It was signed by Director Roos on January 8th, 2021.
Thank you so much. Do you see this? We're on page, let's see, we're on page 5 of the ACO. Can you read paragraph 24, please?
Sure. Violation 1 pursuant to NMSA 1978, section 74.6.10a, Enemy D concludes the respondent failed to complete the requirements of the March 13th, 2012 settlement agreement and has violated condition 10 of DP 1691 by failing to submit to Enemy D a plan to connect Vision Mobile Home Park to the VWSD sewer or to provide Enemy D documentation illustrating that connection to the VWSD sewer would be financially infeasible. And we'll quick, sorry. Enemy D concludes that respondent has repeatedly refused to comply with the act and regulations, evincing a degree of willfulness and negligence. She has control over the events constituting the violation, but has dismissed numerous directives and opportunities to come into compliance.
Thank you. I want to direct your attention to Enemy D Exhibit 5. Can you read the title of this document?
That is the stipulated final order from 2012.
Have you seen this document before?
I have.
Can you read when it was filed?
I didn't know I was going to need glasses. No.
That's okay. To the best of your knowledge, about when was this stipulated final order and settlement agreement issued?
In either 2011, late 2011 or 2012.
Thank you. I want to briefly go down to the signature page. When was this signed?
March 13th, 2012.
And who signed it?
Butch Tongate, Chairman of the Water Quality Control Commission.
Thank you. This is the bottom of the settlement agreement. Can you read the second signature there?
Well, it's by Maricela Ornelas, owner of Vision Mobile Home Park.
And the date in which she signed it?
On February 14th, 2012.
There's a watermark behind this document. Can you read what that watermark says?
That it is this is the only page of the document that has it, but it's the draft watermark, which is then later explained as
Thank you. And can you read this is an addendum, can you read the title of this document?
The Vision Mobile Home Park Settlement Agreement signature page.
And are you familiar enough to summarize rather than read the whole paragraph, summarize what this memorandum says?
Yes, it appears it came from our Assistant General Counsel at the time, Jennifer Howard, explaining that the draft watermark was accidentally included and never removed from the signature page of the settlement agreement.
And is this the settlement agreement that is the subject of violation 1 of the administrative compliance order in this matter?
In part, yes.
Beginning with, if you can see it, beginning with paragraph, well, can you read paragraph 15 and all of the sub paragraphs in there?
Sure. In order to settle the alleged violations as set forth in the administrative compliance order, the parties agree to the following conditions. A, the division has assessed a $24,000 civil penalty against Vision Mobile Home Park in the administrative compliance order. The division will amend the civil penalty to $10,000 due to Vision Mobile Home Park's movement towards compliance. B, the $10,000 civil penalty will further be reduced by the following amounts upon successful performance of each specified task. 1, installation of 2 proper access openings on each septic tank located at Vision Mobile Home Park in the manner and time frame specified in the discharge permit to be issued for the facility, subtraction of $2,500. 2, installation of monitoring wells in the number, location, and time frame specified in the discharge permit to be issued for the facility, subtract $2,500. 3, fulfillment of 3 years of monitoring and reporting requirements as specified in the discharge permit to be issued for the facility, subtract $2,500. 4, fulfillment of 3 years of successful notification of any unintended discharge of water contaminant in such quantity as will with reasonable probability injure or be detrimental to human health, animal or plant life, or property pursuant to 20.6.2.1203 NMAC, subtract $2,500.
Was the civil penalty in this matter reduced by $10,000?
No, it was not.
It was not. Why was it not? Why wasn't reduced? Why was it not reduced?
Monitoring wells were not installed, and there was a difficulty getting the access openings on each septic tank to be installed. It was not done within the permit term required.
So of these 4 items, which of these are outstanding obligations?
Monitoring wells still need to be installed.
Okay, thank you very much. I want to direct your attention to NMED Exhibit 12. Are you familiar with this document?
Yes, I am.
And could you read the title, or at least read the reference? Well, let me get to the title page. I'm sorry. Can you read the title of this document and tell us the number?
It is a Groundwater Quality Bureau discharge permit issued under 20.6.2 NMAC for Vision Mobile Home Park DP 1691.
And can you read the signature line to us, or tell us who signed it and when it was signed?
Sure. Bureau Chief Michelle Hunter. It was signed on April 8th, 2020.
Okay, and so when we're talking about the obligations in this permit, up to this date, when do the obligations under this permit start?
April 8th.
April 8th. Thank you. Can you read the highlighted section here?
Sure. Condition 3, the permittee shall conduct the following monitoring, reporting, and other requirements listed below in accordance with the monitoring requirements of this discharge permit.
And can you read condition number 5?
Sure. Quarterly monitoring shall be performed during the following periods and reports submitted to NMED as follows: January 1st through March 31st, due by May 1st, April 1st through June 30th, due by August 1st, July 1st through September 30th, due by November 1st, and October 1st through December 31st, due by February 1st.
And what is the status of Ms. Ornelas' compliance with these obligations?
We have not received any monitoring reports for the facility.
Thank you. Can you read the highlighted section for paragraph 10, please?
Sure. Condition 10 states, within 60 days following the effective date of this discharge permit, by June 7th, 2020, the permittee shall submit a plan for connection to the VWSD sewer to NMED. The plan shall include, at minimum, documentation on the funding sought, obtained for connection, a timeline for connection, construction benchmarks to be met, and a protocol for reporting progress towards connection. The timeline in the plan shall have a project completion date of no later than April 8th, 2022. NMED will review the plan within 30 days of receipt. If NMED determines the plan is feasible and approves it, the permittee shall commence the sewer connection process within 240 days following the effective date of this discharge permit by December 4th, 2020, in accordance with the approved plan. Compliance with the approved plan is an enforceable condition of this permit. If the permittee believes the plan is financially infeasible, the permittee shall provide evidence of hardship in the form of tax documents or other reliable records along with the plan submittal within 60 days following the effective date of this discharge permit by June 7th, 2020. If NMED agrees that the plan is infeasible, it will notify the permittee by certified mail of the determination of failure, the determination date, and the implementation deadline dates required as a result, and the permittee will be required to implement Part 4 of this discharge permit within 60 days of that notification. Sorry.
Thank you. Did Ms. Ornelas supply a plan to the Bureau by June 7, 2020 to connect Vision Mobile Home Park to the municipal sewer?
She did not.
Did she supply by June 7, 2020 a notice of infeasibility?
She did not.
Thank you. Has she supplied either of those items up until today, June 8, 2021?
She has not.
Okay, thank you. I have no further questions on this item, Mr. Hearing Officer. I'd like to retain Mr. Herman for questioning by the WQCC commissioners, but I have no further questions on this issue.
So to sum up, your exhibits 1 through 24 have been admitted into evidence. There's been no objection. Your request for admission is exhibit 22. It has been entered into evidence. You've presented one witness on direct to establish the violations by a preponderance of the evidence. That's been done now. Are you ready to move into the second phase of your case where you have the burden to show that the civil penalty is appropriate?
Yes, we are.
Please proceed.
Mr. Herman, let's go back to your testimony with regard to the civil penalties. Can you tell us what the nature of your testimony is today?
My testimony, I'm here to testify about how the Bureau determines the civil penalties associated with an administrative compliance order and to describe how the penalties were calculated in this particular administrative compliance order.
I'd like to ask you a few questions about how the Bureau penalties for an administrative compliance order.
Okay.
What are the elements that the Bureau considers when calculating penalties?
The NMED Groundwater Quality Bureau penalty policy identifies 3 things the Bureau should consider according to the Water Quality Act. We should consider the seriousness of the violation, any good faith efforts to comply with the applicable requirements, and any other relevant factors. Taking those factors into account, the Bureau consults with the penalty policy to then consider the appropriate gravity-based penalty calculation, multiple and multi-day penalties, appropriate adjustment factors, and the effects of economic benefit on noncompliance.
And what are the total civil penalties due on this ACO?
I believe they're just above $265,000.
What is a gravity-based penalty?
Gravity-based penalty is a penalty that represents a measurement of the seriousness of a violation.
And how is a gravity-based penalty determined?
A gravity-based penalty is determined by examining the violations for potential for harm and the extent to which the violation represents a deviation from the statutory or regulatory requirement. The penalty policy instructs that the potential for harm represents the risk to public health, welfare, environment, or property, including a threat to groundwater quality standards, a threat to attained designated uses, and threat of direct exposure to water contaminants that may be posed by noncompliance. The policy provides guidance on the factors and considerations to be made when evaluating the potential for harm. Those factors are then used to determine if the potential for harm is considered to be major, moderate, or minor. The policy also instructs that the extent of deviation from the statutory or regulatory requirement is the effect noncompliance may have on statutory or regulatory purposes or procedures for implementing the water quality protection program. Similar to the potential for harm evaluations, the policy provides factors to be considered, which are used to determine if the deviation is major, moderate, or minor. The 2 major, moderate, and minor determinations for those 2 categories are then used to identify the appropriate gravity-based penalty value in a 3x3 matrix that is also in the penalty policy. Each of the boxes in that 3x3 matrix have been assigned different combinations and different values, and they range from $1,500 for a minor up to the maximum allowed $15,000 for a major category violation.
What is a multiple and multi-day penalty?
A multiple penalty is a penalty for a violation that has occurred at different locations or when a requirement is violated at the same location but on separate occasions. Alternatively, it guides the Bureau to avoid multiple violation penalty calculations for situations where the violations are neither independent or indistinguishable from each other. A multi-day penalty is a penalty that is assessed based on the number of days which a single violation has occurred. This type of penalty is specifically identified by the Water Quality Act, and the penalty policy includes examples of types of situations that require the use of multi-day penalty calculations. Multi-day penalties include an assessment of the time frame the violation occurred and includes a determination of the duration of the violation using the evidence available to the Bureau.
And how is a multiple or multi-day penalty determined?
So in general, multiple violations are and resulting penalties are handled separately. So they really become individual violations and penalties, and they're most often are assessed to reflect the appropriate amount for those separate violations. Multi-day penalties are calculated using the same major, moderate, minor determinations from the gravity-based penalty. Penalties in the major, moderate, and moderate major categories have mandatory penalties for days 2 through 60 of the violation. Multi-day penalties for major, minor, moderate, and minor major violations are deemed to be presumed in favor of applying multi-day penalties for for the 2 to 60 day range. And lastly, the multi-day penalties for moderate, minor, minor, moderate, and minor, minor violations are discretionary and determined for days 2 through 60. In all cases, the penalties for days 61 and beyond are completely discretionary, and the previous determination is used to determine the dollar amount that will be used for each day of a violation. So there's a new 3x3 matrix provided in the penalty policy, which includes ranges of daily penalty amounts for each category, and the dollar amounts range from $150 to $300 for minor penalties, and then up to $3,750 to $7,500 for a major category. So once we determine the duration and the appropriate matrix box is identified, the policy instructs the Bureau to analyze the situation in the context of the policy's broad goals of ensuring fair and consistent penalties, which reflect the seriousness of the violations and promoting prompt and continuing compliance, and lastly, deterring future noncompliance.
And what are the adjustment factors?
Adjustment factors are considerations made that are not considered when calculating the gravity-based penalty. Adjustment factors can be positive or negative factors that represent a need for additional consideration by the Bureau. These factors allow for flexibility in the penalty policy, providing a route for development of a penalty that is appropriate for the violation and specific situation.
And how are the adjustment factors determined?
Some negative factors result in an increase in the penalty, including the degree of willfulness and negligence, or the history of noncompliance at a facility, or other unique factors. And some positive factors result in the reduction of penalties, and those can often include good faith efforts, the facility's ability to pay, or other remedial actions that they have taken elsewhere.
What is economic benefit with regard to penalty calculations?
The economic benefit is a value that has been determined to be the amount of money that the violator has either avoided paying as a result of the actions that led to the violations, or the amount of profit made by a violator as a result of the actions that led to the violation. The Bureau can consider the benefit from the delayed costs, including items that will be required to come to be installed or done to come into compliance, including requirements similar to the installation of monitoring wells and equipment. Avoided costs are the expenditures that the violator has that have been nullified as a result of the noncompliance and their failure to comply. These costs usually fit into the category of operations and maintenance costs for the facility.
And how is economic benefit determined?
Well, because the savings are derived from delayed costs, differ from those derived from avoided costs. The two different costs are generally calculated separately. For avoided costs, the economic benefit equals the cost of complying with the requirements, adjusted to reflect the anticipated rate of return and income tax effects on the facility. Delayed costs are expenditures which have been deferred by the violators' failure to comply with the requirements, and that the violator will eventually have to spend in accordance. The violator will eventually have to spend the money in order to achieve compliance. Delayed costs are the functional equivalent of the capital costs.
Okay, I want to ask you about how you determine the penalties for the ACO in this matter. What were the considerations that went into calculating the civil penalty for violation 1?
So we evaluated the potential for harm, and the potential for harm in this violation was determined to be categorized as major. This determination included an evaluation of the discharge's potential impact of groundwater at the site, the discharge's contaminant contents, and the duration of the discharge being unmonitored. The discharge includes contaminants that threaten human health and can result in exceedances of the human health standards of our regulations that we call the 3103A category, and that standard would be for nitrate. Discharges at the site have occurred unmonitored for many years, and the violator at times has been in contact with the Bureau and has promised to comply with the permit requirements. This has resulted in very little actual compliance, and the Bureau has been told many times that delay of installation of monitoring wells at the site has been due to contractors stealing money or shady business practices by drilling companies. The Bureau determined through this evaluation that the degree of potential for harm arose to the level of being major as well, as defined by the policy. And I'm going to quote the policy here. It says the violation poses or may pose a substantial risk to public health, welfare, environment, or property. The actions have or may have a substantial adverse effect on the water quality protection program's ability to implement the Water Quality Act and Wqcc regulations. So we determined that had been met. The regulatory and programmatic harm for this violation also contributed to the extent of deviation determination, and the Bureau considers the respondent's compliance history and unwillingness to comply with the fundamental and basic requirements of the regulations, and their failure to comply with even the most basic requirements of the discharge permit and their subsequent violations. The Bureau determined that this violation arose to the policy definition of what major is.
Does the Bureau consider this penalty appropriate?
Yes, the Bureau does consider this penalty appropriate. Groundwater at the site is considered to be very shallow, less than 20 feet in certain areas surrounding the facility, where there are multiple domestic wells in the area that provide water to private residences. The discharge is occurring in an area that is in close proximity to the San Juan River, and the discharge includes organic nitrogen in the form of nitrate and ammonia, which easily converts into nitrate in the ground. The discharge also has the potential to transmit disease due to the pathogens present in human waste. All of this is being discharged to the system that does not include any disinfection technology. The factors resulted in a gravity-based penalty of major being applied in the amount of $15,000. The violation category of major indicated a mandatory multi-day penalty addition, and the violations were determined to be ongoing from the previous discharge permit, the ACO previously issued, and the other notices of noncompliance and notices of violation we had issued them. This resulted in an assessment of a multi-day penalty for days 2 through 60, and the Bureau exercised discretion not to assess penalties for days 61 and beyond. The Bureau used discretion to assess the lowest amount possible for a major category in the multi-day matrix, which was $3,750 per day. The Bureau did not include any adjustment factors in the calculations, but it did include the avoided costs of the required monitoring well installation and additional one-time hydrostatic testing that had not been completed of the septic tanks. This represents the capital costs associated with noncompliance, and through a similar method, sorry.
Thank you. And what were the considerations in calculating the civil penalty for violation 2?
For this violation, the Bureau considered the extent to which the violation had occurred during the permit term and the extent the violator made efforts to comply with the monitoring requirements of the permit. Previous experience with the violator has shown that there's little to no willingness to comply with the requirements of the permit. And while many promises to comply have been made, none of those promises have resulted in submissions of monitoring reports. The absolute absence of monitoring report submission resulted in a potential harm categorization of major and an extent of deviation determined also as major. This resulted in the gravity-based penalty of $15,000, and the Bureau did exercise discretion not to assess a multi-day penalty and applied no adjustment factors. The economic benefit was also not calculated in accordance with the exemptions provided in the penalty policy.
And why does the Bureau consider this penalty appropriate?
The Bureau considers this penalty appropriate because one of the main functions and controlling factors of a discharge permit are the requirements to monitor the discharge permit or the discharge. The Bureau cannot evaluate the impact or even the potential impact of the discharge if monitoring reports are not submitted. The extent of the missing monitoring reports goes beyond any other site that I have experience with, and the lack of submission leaves the Bureau completely unable to assess the impacts of the discharge to groundwater that is shallow and being used by people in the surrounding areas.
And I will, one last question, I think, for you. Can you briefly summarize how the Bureau met its requirements in this matter?
Sure. The Bureau published the hearing notice, the public hearing notice in the Albuquerque Journal and the Farmington Daily Times, as required by 20.1.3 NMAC. And the Bureau also sent the notice to anyone that was on the facility-specific mailing list.
Okay, thank you very much. Ms. Jones, can I share one more time? I apologize. I want to get into the record the exact amount of the penalties for the benefit of the commission.
Please go ahead.
Thank you. Mr. Herman, can you see this document?
Yes.
Can you read the total penalty from item 4?
Sure. For violation number 1, the total penalty is $250,000, $250,050.
Thank you. And can you read the total penalty from item 4 on violation 2?
Sure, it is $15,000.
Can I ask you to do a little math for us and tell us what the total penalties are in this matter?
$265,000, $265,050.
Okay, thank you so much. I have no further questions on direct for Mr. Herman. And if it pleases I'll defer to the hearing officer how he wants to proceed.
Okay, so that concludes your case in chief.
No, Mr. Hearing Officer, because I have a couple questions for Bureau Chief Michelle Hunter that I think would be helpful for the commission. So what I'd like to do is call the panel, qualify the panel, and then ask Ms. Hunter a couple brief questions, if that's okay with you.
So the panel is going to stand for cross-examination, right?
They are.
Okay. Why don't you call Ms. Hunter by herself? We'll get her sworn in. You'll ask your questions on direct to her, and then you can present the panel after we swear in your third witness for cross-examination.
That makes more sense. Thank you very much. The Bureau calls Michelle Hunter.
Mr. Chakalian, would Mr. Herman be available for cross-examination, assuming somebody's here to cross-examine?
Yes, Mr. Wade, he will be.
Okay.
Thank you.
Ms. Hunter, I need to have you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Hunter, can you state your name and position for the record?
Sure. I'm Michelle Hunter. I'm the chief of the Groundwater Quality Bureau.
And can you tell us how long you've been in your position?
Sure. I've been the chief for just about 6 years. And before that, I worked as technical staff in the remediation oversight section in the Groundwater Quality Bureau.
Thank you. I want to ask you a couple questions about this case. How serious is this case, not just on its own merits, but in the history of the Bureau's compliance efforts?
As Jason Herman stated, we really haven't seen an individual or an entity that was so unwilling to adhere to any condition in its permit. So this ranks up there with the top, very, very few permittees. In fact, I know of no other case where an entity didn't ever submit the things that were required, and when they submitted some things they were woefully inadequate with respect to compliance of those conditions.
Okay, thank you. I know this is a little bit out of the blue, but I do want to ask you, to the extent that you remember, can you tell us about how Ms. Ornelas came under the jurisdiction of the Environment Department? How did that happen? How did it end up that Ms. Ornelas had the first discharge permit back in 2012?
From what I recall, she had bought this mobile home park from a different entity who had not gotten a discharge permit from us. And I could be misremembering, but we became aware of it and required a discharge permit from this 25 space mobile home park.
Okay, thank you. And with regard to the civil penalty, how serious is that, both on its own and in the history of the Bureau's compliance efforts?
I am unaware of any other mobile home park that has garnered such a large fine. We have had several mobile home parks throughout the state who have not been in compliance with permitting requirements, laws, and regulations per se, but we've never seen one that was this bad. And in general, mobile home park facilities are fined in the $15,000 to $40,000 range generally. It's more of an attention getter to compel people to do what they need to do with respect to our rules, our regulations, and the Water Quality Act. This is a case unto itself. I've never seen anything like it in my 6 years.
Thank you, Ms. Hunter. I have no further questions for Ms. Hunter, and the department rests its direct case, Mr. Hearing Officer. If it pleases the hearing officer and the commissioners, I would like to qualify Ms. Avery Young and have Ms. Young, Ms. Hunter, and Mr. Herman sit as a panel for questions from the hearing officer and the Wqcc.
Okay, Mr. Vigil, before we do that, what I'd like to remind the commissioners is that the Vision Mobile Home Park and Maricela Ornelas filed an answer, respondent's answer to administrative compliance order requiring compliance and assessing civil penalty. And she digitally signed this answer on February 9, 2021 at 2:29 p.m. They filed in this answer a motion to dismiss, and I think the commission will remember that they dealt with the motion to dismiss on May 10 at the hearing where Ms. Ornelas was present. They decided to deny the motion to dismiss, and they appointed me as the hearing officer. I say that because Ms. Ornelas was here this morning, along with Mr. Patton, for a short time, and she spoke as a public comment. So I remind the commissioners that Ms. Ornelas was aware. She had been put on notice. She has a due process right, as any respondent does. But I mention that because I want to be very clear that she knew about today's compliance order hearing and the requirement that today is an evidentiary hearing and her one and only opportunity to participate in that. So let's get your third witness sworn in, Mr. Vigil, before they sit for cross-examination.
Thank you very much. The Bureau would like to call for cross-examination of Ms. Avery Young.
Ms. Young, I need to have you raise your right hand to be sworn in. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Young, can you state your name and position for the record?
Avery Young, I am an environmental scientist and specialist advanced in the pollution prevention section of the Groundwater Quality Bureau.
And Ms. Young, could you, if it's possible and comfortable, can you lean in a little closer to your microphone?
Yes, sorry.
Thank you. Can you describe the duties associated with your position?
Yes, I currently manage 66 domestic, industrial, and reuse groundwater discharge permits. I'm responsible for conducting inspections at my facilities around New Mexico. I work with permittees to accomplish voluntary compliance with the New Mexico Ground and Surface Water Protection Regulations, which is 20.6.2 NMAC. If voluntary compliance cannot be met, then I work on enforcement actions, including notices of non-compliance, notices of violation, and administrative compliance orders. I also serve as the health and safety officer and inspection and public records coordinator for the pollution prevention section.
And how long have you been in your current position?
1 year and 11 months.
And could you give us a brief overview of your relevant educational background and training?
I have a bachelor's degree in international affairs, concentrating in environmental resources, and a minor in geography. I have a master's degree in water resources, concentrating in policy and management from the University of New Mexico. I have been employed by the Groundwater Quality Bureau since August 2018, first as a geoscientist operational, and then in my current position as an environmental scientist and specialist advanced. I have written and overseen numerous enforcement actions to gain compliance from permittees, as well as attended trainings on the subject.
And approximately how many groundwater administrative compliance orders have you been involved with?
This is the second ACO that I have been involved with. I was the primary writer for the administrative compliance order for Cannon Air Force Base in 2020. As Mr. Herman already stated, ACOs are pretty rare for the Groundwater Quality Bureau, and there is little opportunity to gain experience with them.
Okay, thank you very much. The Bureau's panel will sit for questions from the respondent if Ms. Ornelas is available, the hearing officer, and the commissioners.
So let's start with Ms. Ornelas. Are you with us? Let's go to the commissioners.
This is Stephanie Stringer. I had a question for the panel to describe the explanation provided by Mr. Nalos about the deliveries to the incorrect address and what actions the department may have taken to deliver it to the correct address.
I can speak to that. The documents and all of our communications with Mr. Nails were both sent in paper format as well as electronically. We did send the ACO via FedEx as well as certified mail. Both packages were delivered and we received a return receipt for the ACO in the certified mail. So we got a little green slip back with a signature from a facility representative that they did receive that. So we have confirmation in multiple formats that she did receive the documents. We generally wouldn't take any further actions on those situations. We have also utilized the address that she provided us with the application for the groundwater discharge permit, and have not been provided any other address other than that one address inside that application.
Thank you.
Mr. Hearing Officer, this is Commissioner Thompson. Hello.
Please proceed.
Thank you. I have, there's a long record of the respondent not providing monitoring data. One question I had, and I couldn't find it in the record, were the 3 required monitoring wells ever drilled?
No, sir.
I'm sorry, was that a yes or a no?
No, they have not been drilled. They to date have not been drilled.
Thank you.
I'm going to wait for a moment to give the other commissioners a chance to ask any other questions. Not hearing any. I don't have any questions myself. Mr. Vigil, did any of those questions surprise you in a way that you need to put on a rebuttal case?
No, Mr. Hearing Officer, thank you.
You're welcome. I'm going to give the respondent one more opportunity to participate. Okay. This hearing.
Hearing Officer Shakalan? Hearing
Yes,
Officer
Mr.
Shakalan?
Sanchez. I hear you, sir.
Thank you. Thank you. A couple of things. One is regarding the testimony on the total penalty assessment. Was that testimony, that shared screen, was that an exhibit? And if it was, can we have the exhibit number, please?
Mr. Vigil?
Thank you, Mr. Hearing Officer, Counsel Sanchez. That was an attachment to the ACO. So it actually came with the administrative compliance order itself. It is not an exhibit. But Mr. Sanchez, I am happy to send that to you and anyone, of course, if they want it. So please let me know, and I'm happy to send it now or after the hearing.
Well, my
Mr.
concern
Sanchez.
is that be part of the, my concern is that be part of the record.
Mr. Sanchez, when Ms. Ornelius filed her initiating document, her petition for a request, the rule 20.1.3.19 required her to file that administrative compliance order. It was not attached. We worked strenuously, the administrator and I, to get that compliance order from them, and it was finally sent. It is part of the record, and I think it's also on the website, isn't it, Ms. Jones?
Yes, sir.
So, Mr. Sanchez, does that
Thank you.
satisfy it, or do you want it some
It
other
does,
way?
and it is part of the record. It was subsequently, as I understand, submitted by Ms. Ornelius and filed by the Wqcc administrator. The other question I had is, are the proofs of receipt of service, have those been made part of the record? There was testimony that they were sent by online by UPS, FedEx, I think it was. And I'm wondering whether those receipts of service have been made part of the record.
On some of the documents, and I want to say that it is our exhibit number 18. That's just thinking off the top of my head in terms of the exhibits that we gave. But for the the discharge permit that we had sent her for comments, yes, we do have return receipts, and I do believe that is NMED Exhibit 18.
Thank you.
Mr. Sanchez, does that conclude your questions?
I was concerned, since we have a pro se respondent who has not appeared, that we would have evidence in the record that service was made of all the relevant documents. Thank you.
Of course, definitely. And she has actually appeared. She did file an answer. She did appear in front of the commission in
Yes,
May.
hello, I'm here. I am here. Nobody came. I'm muted every phone call. I'm listening to the conversation, and nobody's taking me into consideration.
Ms. Ornelas,
So I don't know why.
Ms. Ornelas, can you stop for a moment?
Yes, I
First
just
of
want to make
all,
sure I'm here.
I've asked multiple times over the last hour for you to enter an appearance. There has never been anything from you. So are you entering an appearance now?
Yeah, I've been here this whole time since the beginning, since we started in the morning. I've been answering questions and nobody's talking back to me. It's like I'm muted and nobody's taking into consideration.
Okay. Ms. Ornelas, would you enter your appearance, please?
How do I do that? I'm on two phones right now.
Ms. Ornelas, I'm asking you to announce who you are.
Okay. My name is Maricela Ornelas, Vision Mobile Home Park. I've been here listening to the conversation.
Vision Mobile Home Park where?
For Kirtland, New Mexico.
I'm sorry, where?
For Kirtland, New Mexico.
Okay, is there an address in Kirtland, New Mexico?
One Road, 6367.
Okay.
Kirtland, New Mexico.
So, Ms. Ornelas, you would normally have an opportunity to present your case in chief and rebut the state's case, but you haven't filed a witness list and you haven't filed an exhibit list. So, in the effort to be fair to you, I'm going to give you an opportunity to go under oath, to be sworn in, and to make a case for yourself on either why the violations didn't happen or why the penalty is not fair, but you will not be able to enter exhibits and you will not be able to call other witnesses. Do you understand?
Okay.
Okay, so would the court reporter please swear in Ms. Ornelas? And Ms. Ornelas, do you have a way of showing yourself? Because I know court reporters don't like to swear in witnesses who they can't see.
I've been trying to get on the system since we started, so I'm going to try again to where this prompt to go to be able to get online. So I've been trying all morning to get online, and that's why I've been on the phone struggling with you to hear me. I've already called from 4 different numbers, so I'm glad you finally recognize that I'm here listening to what's going on.
Let me ask the commissioners, would now be a good time for another break? Maybe give the opportunity for the respondent to get onto the video?
Yes, I'm working on it right now.
Yes, and Chairman Wade, I think our court reporter would appreciate a short break as well.
Okay, let's take a 10-minute break this time, a little bit longer. We'll come back at 12:15.
Okay, I will be here.
Pam?
Yes, that's fine. Yes. I will be here.
No, Ms. Ornelas, I'm asking Pam, the administrator, to help you use this program properly so that you can show your video. Because right now, all we can do is hear you, but you need to enable your video.
Okay, I'm trying to get that on my...
So Pam, will you help her with that while we're on this break?
I will certainly try.
Okay.
Thank you. Appreciate it.
Ms. Ornelas, are you in front of a computer?
I am right now, yes.
Okay, there was, you might go to the website.
Okay.
And to the Water Quality Control Commission page. And follow that link to the minutes and agendas section, or actually you can even go to the home page of our website of the water quality.
Water quality, okay.
Mm-hmm.
Okay, let me see, I got approved here.
And you will see midway down the home page that it says today's meeting, the Water Quality Control Commission will meet June 8th. And immediately to the right of that is a hyperlink on the word agenda.
Okay, I'm trying to get in right now. No, it's not doing it. Wait just a minute.
While you work on that, I'm also going to send you the link to your email address. Okay?
Okay, I think that'll probably be easier. I'm trying to get in here. I'm trying to get connected here. I can just start crying, you know.
Hi, Pam.
I'm trying to get into my email.
Yes, Mr. Sanchez.
Are we still recording?
Yes.
Okay, great. Thank you.
Thank you. Okay, so I'm at groundwater.
Ms. Ornelas, please look at your email address. Madai Corral just sent you the link, and she sent it to the last email address that I received something from you, and that is maricelasornelas@gmail.com.
Okay, let me go there. And I'm working on it. I'm trying to log in. I consider saying there's no issue. I'm saying there's no internet. I have no internet right now. I'm sorry. It's completely turned off. Okay, let me see. Come on. I just want to get in. I just want to get in. It's driving me crazy now. I'm saying it's no internet. It's not letting me get it from the line. I don't understand. No internet, no internet. I don't understand. I'm on. There's no internet. I don't know. It's just completely shut off. Everything's saying it's done. All right, just. I'm sorry. I'm working on internet. It's saying I have no internet.
Okay, well, we're still here.
Okay, I'm working on it. It's not letting me in. I'm just trying to get in. Oh my gosh, I can't believe it. There's no nothing. It won't let me go in. I'm saying it won't go in, won't do nothing. Ridiculous. I can't believe it. Neither computer's working. Neither computer. Come on. Oh, wake up. Without internet, nothing. Oh my gosh. Okay.
Pam,
Yes, sir.
what time are we getting back on the record?
12:15.
4 more minutes. Okay.
Correct.
How's Miss Ornelius doing?
I'm working on it.
She's having difficulty. She has no internet. I directed her to the website where she could find the link, and
Right.
Miss Corral also emailed her the link.
Okay. And so
I'm on it. I'm trying to get online.
well, Ms. Ornelius, if you're not online by 12:15, we're going to have to proceed in the way that we are right now. So
I'm sorry. I'm trying to connect. It's saying I have no connection. My internet is.
okay, we'll put that on the record. Pam, we'll put that on the record that you tried.
Okay, yeah, Mr. Hearing Officer, the recording is continuing. It's on the record.
Okay.
Okay, wonderful. Thank you.
Okay, so you send it to Maricela Ornelas at Gmail, and I'm on Maricela Ornelas right now at Gmail. Angie Perry, maybe? Let me see if I got something from Pamela Jones.
Her last name is Corral, Corral.
Okay, so I'm in Pamela Corral. Okay, so Pamela Corral. Let me see.
No. Her first name is Madai, Madai Corral.
One more time. Madai.
Mad as in dog. AI.
Madai.
Ms. Jones?
Yes, sir.
Ms. Jones, we're gonna leave it the way it is. We're gonna have Miss Ornelius appear by phone, and you'll explain to the court reporter the problems, and then we're just going to continue the hearing the way it is.
Okay.
Thank you.
Okay.
Pam, this is Purvi. Did you say that we're starting back at 12:30?
Yes, ma'am.
Okay.
No, we're not. No, it's not 12:30. It's 12:15.
Okay.
I'm sorry, 12:15. Yes, sorry.
In 1 minute.
Hey, it's 12:15. We'll go back on the record for this public meeting. Ms. Jones, can you do a roll call of commissioners?
Yes, sir. Beginning with Commissioner Candelaria, who is absent. Commissioner Certain, are you back?
Yes.
Commissioner Dominguez.
Present.
Commissioner Hutchinson.
Here.
Commissioner McWilliams.
Here.
Commissioner Musharafi.
Here.
Commissioner Modi.
Present.
Thank you. Commissioner Patton. Commissioner Patton, are you back?
Yes, I'm here.
Thank you. Commissioner Rader? Commissioner Rader, have you joined us? Commissioner Cipher? Commissioner Cipher? Commissioner Thompson?
I'm here.
Commissioner Timmons? Commissioner Timmons, are you back? Let's go back up to Commissioner Rader. Have you joined us? Commissioner Cipher, are you back? Commissioner Timmons?
I'm here. My internet dropped right there.
Okay, very good. Thank you. Vice Chair Wade?
Here.
Chair Stringer?
Here.
Let's try Commissioner Rader. Have you joined us? Commissioner Cipher? Vice Chair Wade, we're missing 2 commissioners. I don't see anything in the chat.
Apologies, this is Kelsey Rader. I had to step out for a moment.
Oh, okay. So thank you. Commissioner Rader's here, and let's try Commissioner Cipher one more time. Okay, Vice Chair Wade, Commissioner Candelaria is absent. Commissioner Cipher has not rejoined us. Everyone else is present.
Okay, I think we have a kind of a procedural matter to discuss while we're waiting for Commissioner Cipher anyhow. Mr. Chikalian, I'll let you discuss, Ms. Jones, also maybe discuss the efforts made to bring the respondent on to the video and what the result was.
Ms. Jones?
Okay, when we broke at 12:03, I left the recorder running and spoke with Ms. Ornelas, instructed her how to find the link on the WQCC page on the environment website. Concurrently, Ms. Corral emailed the link to Ms. Ornelas at the last email address that we received something from her, which was earlier this morning, and that was Maricela Ornelas at gmail.com. Ms. Ornelas indicated that she did not have internet.
Okay, and Mr. Chikalian, how would you like to proceed given that she's not able to join by video?
She's present. She says she has been here for the whole time listening. So she's aware of what's going on, in my opinion. I was going to start by giving her an opportunity to cross-examine the state's witnesses. Even though that has passed, I was going to reopen cross-examination for her and then let her put on her case in chief.
Okay, I'm comfortable with proceeding this way, but I'd like to ask the commission counsel as well. Mr. Sanchez, do you have an opinion?
Vice Chair Wade, I'm comfortable with what's on the record so far. The only thing I'd ask is to have Mrs. Ornelas stipulate or agree on the record that she is fine with proceeding in the manner that she is telephonically.
Okay.
Yes, I'm fine with me.
I might have interrupted you a little bit there, Ms. Ornelas. Can you repeat that?
Yes, I don't mind appearing telephonically.
Okay, Mr. Chikalian, proceed.
Okay, so Ms. Ornelas, you listened to the testimony of the state's 3 or 2 witnesses and 1 witness on cross-examination, although there was no cross-examination as far as I remember. Do you have any questions regarding anything that they said that you would like to explore?
I really do, because I see that
Ms.
I'm being
Ornelas,
told that
Ms. Ornelas, this is
Are you
not
there?
time for you to make comments. Your time to testify will be when you make your case in chief. This is the time for you to ask specific questions to the witnesses. So please ask a question.
To Mr. Herman, Mr. Jason Herman, he was saying that I did not provide monitoring well documentation that was required every February and every August. And I would like to ask him to who I was supposed to give this to, because I've been sending to the same email and to the same address for years my records of monitoring wells and monitoring reports. I've always complied with my monitoring reports, so I don't understand where they're saying that I've not provided any at all since the beginning. But Mr. Herman was mentioning that I did not comply on any of these requirements, and that's specifically not true. So I
Mr.
want to
Ornelas,
find
what is
out
the
where.
question? Mr. Ornelas, you'll have an opportunity to put on your case in chief. This is the time for you to ask questions. So without making statements, what is your question to Mr. Herman?
My question, Mr. Herman, was that he had mentioned that I had not been providing any reports to the state. I wanted to ask Mr. Herman to who I was supposed to send these to, because I have been providing.
Okay, thank you. Thank you, Mr. Ornelas. The question is, to who was she supposed to send those to, Mr. Herman?
The reports would be sent to either the person that is assigned to the permit, which for the permit term was Avery Young. She was the permit reviewer and writer, and she's present. She can speak to that. Prior to that, the monitoring reports should be sent to the Groundwater Quality Bureau at either our address or any of our numerous email addresses associated with any of the permit writers or permit reviewers in management.
And Mr.
Thank you,
Herman,
Mr.
it's
Herman.
your understanding that I'd never sent any of these in, that you don't have any record of my monitoring reports? I believe it was you who I spoke to that told me that there was no specific form to fill out that I had to give you. In January, I provided every single record. When I received the recommendation that you asked me, you told me to please provide them, and I did provide every single one for all the time that we were providing reports. So I was never informed of any mistakes
Mr.
that I was
Ornelas, I'm
making.
going to interrupt you. Mr. Ornelas, I'm going to interrupt you. And if I start speaking, please stop. Mr. Ornelas, you are testifying. This is not your opportunity to testify. You are only allowed to ask questions at this time. You will have an opportunity to make your own case under oath. You're not under oath yet. Nothing you say is evidence yet. Do you have any other questions for these 3 witnesses?
For Mrs. Avery Young as well, I have a question as well for her. Did she not receive any of my documentation that I've been providing the state at all for all these years? Has she not received anything? Because I believe it's her testimony that she has not received anything.
Will you let her answer,
from me.
please? Ms. Ornelas, will you let her answer?
We did receive monitoring reports for certain years, I believe between 2013 and 2018. They were woefully inadequate. None of the required monitoring had taken place. None of the meter readings that are required for the permit were included, nor were the monitoring wells installed. Therefore, the monitoring well results were not included. So although she did submit pieces of paper, they did not have any information that was required in the discharge permit.
Thank you, Ms. Young. Is there another question, Ms. Ornelas?
On the discharge permit that I was given in 2012, I heard Mrs. Hunter explain that in 2012 was the report of my report to the state. My question to her is that, or to her as well, is that in 2012, she said that basically that they had come into knowing of my park. I wanted to ask Mrs. Hunter, was that when she realized I was existing, because I had been the one to report to the state? The state did not find me. I came to the state for help, because when I purchased my park, it was full of crap throughout the whole road. So I came to the state for help, to tell me what to do to fix the problem of the prior owner. And Mrs. Hunter had mentioned that she didn't recollect. My question to her was that, is she recollecting that I am the one that came forward to help the state improve my park and get things registered correctly?
Okay, let's let her
It's
answer
not
the
the state that
question,
came up
Ms.
to me.
Ornelas. Ms. Hunter, would you answer the question, please?
Sure. I was not the bureau chief at the time. I merely looked in parts of the file to understand the application. I just reviewed the application in 2012, so I don't have specific knowledge regarding those events per se. So I don't know. I don't really know, and I did say that I wasn't positive, and I may have misremembered exactly how the part came to our knowledge, but yeah, I was not the chief at the time. I was merely reviewing the file. In my recollection of that was what I recounted.
Do you have any
Okay,
other
thank you.
questions
I
for these
just-
witnesses?
Not at the moment. I can
Okay.
come back to it if I come up with something.
No, you won't be able to come back to it. So are you ready to put on your case in chief?
I believe so.
Okay,
I'm on my own.
so I'm going to ask the court reporter to swear you in, even though she can't see you.
Okay.
Ms. Ornelius, would you please raise your right hand to be sworn in?
Yes.
Do you swear or affirm that you are Maricela Ornelas?
Yes, I am Maricela Ornelas.
And do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay, Ms. Ornelas, I'm going to ask that you put on your case in chief. So please proceed.
Okay. I would like to start by saying that I purchased this park in July of 2008. I purchased it for $225,000. And at the time, the gentleman that owned the park was an experienced and a licensed septic installer. He installed all the septics of the park. They were never approved, I believe, by the state. The state had no understanding of my park until I came to the state when I purchased it, because of the fact that we had over 4 leach lines that were spilling crap and pee, and you can literally see the defecation of the road of all the kids playing in it when I purchased. The state had no idea of this park and the horrible conditions that it was in. It was drug infested and crime infested in front of the police station. I purchased the park from a man that was almost 85 years old, who had dedicated his life to building the septics and the ponds. That was his career, his lifetime career, building these septics. So he did it for his park. I also, when the sewage section I updated the system when I applied for the discharge permit to be able to find out what it is that we need to do to improve the living standards to the community, as well as the people there. It took me 2 years to be able to get out the crime and the infestation of drugs, to the point where we even had the assistant manager raped the week that we purchased. The park was really, really bad. We went in, we informed the state, and we started fixing the state. On the first permit, on the discharge permit, we improved all the leach lines. I invested over $150,000 in the park, improving the crap and the connections to the park because there was literally crap in the roads. We fixed all of that. We fixed all the leach lines for them to be specific. We fixed all the connections. Since we purchased the park, we have complied with the orders as best to our knowledge of what was told to us. We were informed also that when connection was available, we would be the first ones on the list. That obviously did not happen as much as I fought for it. So approximately about 2012, I saw the excavation being done. By the time 2012 hit, I had already had 4 years in the park, and I've already improved the park dramatically in the sense of all the leach lines were fixed. No more crap was being pulled out of the streets. There was no more discharges. There was no more groundwater, disgusting crap coming out of anywhere. I have improved the park completely this whole time and providing the maintenance to every septic system constantly in the park and providing those also to the groundwater with all my records of how I've been maintaining the park and pumping the systems out correctly every year, and if not more than I needed to. I believe I did talk to a gentleman that was in charge of the Lower Valley Water Co-op. He was the one pushing all the men and the contractors to connect to the system. They opened up right in front of me. I had been adamantly calling people left and right. I had paid several contractors to help me connect, including the main engineer for Lower Valley Water. I was told by him that I would never get the chance to connect unless I went through him. I paid him $500 for the Lower to connect me and to get me everything going with the contractors and what I needed. I was ignored, and I phoned him many times, went to Lower Valley many times to be able to connect, since I knew the park next to me was really, really damaged in the sense of groundwater. It was affecting my park, and as they were telling me. So I do have a monitoring well. It's one that was there when the older man put it in. We have a monitoring well. It is now dry from where it was located. That monitoring well is not in uses. I have been providing maintenance to New Mexico Groundwater every year concerning our pond systems. We have not had any discharges at all. I've not had to report since the beginning of the discharge of 2012. We have not had any discharges of anything in our systems or any crap or anything coming out in groundwater. That's why no reports have been made, because we have not had those problems. I fixed all the problems that were pending with the park when we purchased and informed New Mexico Groundwater of the repairs that I was making. Also, I did also feel like I was being blacklisted, because no matter how much I tried to connect, to talk to the officials, to talk to Lower Valley Groundwater, paid several contractors to help us with monitoring wells, people basically just left our side. Phone numbers were disconnected. We tried to get in touch with these people, even though we paid them, nothing was done. I am a single mom. I have no husband, and I have 4 kids. That this is my life savings, my life's work. I have already done 5 different mobile home parks. I'm currently improving one in Colorado. This one here has completely been updated and upgraded. We have not been ignoring the New Mexico Groundwater, for we are the ones that went to you for help. I'm the one that went to you for help to say, please help me fix and provide a better system. My system right now is working very well. I don't have anything coming out of anywhere. It is not like it was. It is not in any way showing any kind of problems for us, and any problem that we had arise, we would attend it immediately and inform New Mexico Groundwater if there is a problem. As of this point, I've hired 4 professionals to help me with my park and connection. In the beginning, it was not being connected because there was no connection even allowed. There was nothing being done in the city for connection to anybody. When the main park next to me, the big park next to me, connected, I went through everyone I could and called everyone saying, please, I need help to connect this part. I was willing to do the groundwater to connect it all, since I have contractors that can possibly do that. I have one that can do that today, that can help me connect in my facility. And it was my understanding that on May 10th, when we went to court the last time, we have been trying for 3 weeks to try to get settlement. And we were told that we can get settlement on the day, even the day that we were supposed to speak, we were told that we can do settlement. We worked hard to get settlement, and I brought in someone else, paid them to comply, to be able to connect and do what's right, finally, and get everybody paying attention to me, because this is what I've been asking for a long time, but I haven't had anyone that's willing to work with us that I paid that actually comes back and does the work. I also hired a contractor for monitoring wells. He did take a deposit, said he would be back, do measurements. He never came back. His phone was disconnected. I tried again with another person on the list for the state. I also did that as well. I followed the rules on the state paperwork as best as I could to be able to comply. I am not complying. My system is working very well. There's nothing wrong with my system right now as it is, besides the fact that we need that.
We seem to have lost her.
Hello?
Yes, Ms. Ornelius, we're here.
I'm sorry. I just completely, my phone just cut off completely. I'm here.
Would you like to continue?
Yes, please.
Okay.
I also.
Let me, Ms. Ornelius, before you continue, let me tell you something. The evidence that I am allowed to admit into this hearing is relevant evidence. Now, you were listening when I explained what the burden is of the department, but I'm going to read it again because I want to make sure you understand. At a compliance order hearing, the department has the burden of going forward with the evidence and of proving by a preponderance of the evidence that the violation occurred. Okay? So we're here to gather evidence on whether or not the violations that are in the compliance order either occurred or didn't occur. All of this other information you're giving us is questionable on whether it's relevant or not. I haven't heard a motion from anyone, so I'm not going to make a ruling on it. However, you would do yourself some good if you spoke directly to the violations that were in the compliance order that you received and that you filed an answer to. Then your other burden at this point, because the state has established a prima facie case, is whether the civil penalty is appropriate. So that's what your testimony in your case in chief should be about.
Okay.
Do you understand?
Okay, thank you for helping me with that.
You're welcome. Go ahead.
So on the civil order and the penalty order here, I find it to be completely just bogus in the sense where, I mean, you're charging me more than I've even paid for the facility, and I've been trying to do this with more than anyone else. I've been the one begging for help to get this resolved. Now, I am willing to connect. I am willing to do what we need to for the betterment of the community and for the water. I'm 1,000% in to do this. I need help in the sense where I need a little bit of time, because as you guys sent me records in June of last year, everything was shut down. There was not one contractor even answering the phone. There was no way I can get anything accomplished last year because of COVID. And most of the people got COVID. So right now my park is struggling because we have not had people pay since July, September, August of last year. We have over 7 lawsuits right now currently in our park for lack of non-payment of rent. And we're struggling with also the financing to the park because of this lawsuit. Now the lawsuit has caused more problems for me to finance the park and redo the new loan that has to be done on July 1st. So July 1st is the deadline date for this to be resolved. And I tried everything and I'm sure Mrs. Pamela, as well as Jason, Mr. Beagle, as well as Mrs. Hunter know that Mr. Patton was working diligently trying to get us to connect. The problem was that I didn't have the $5,000 and the money necessary at the time right now because we are in such really, really hard spot due to the fact that we cannot refinance because of this lawsuit. I cannot pull any money out to fix the problem because of this lawsuit. And even though we tried to get some kind of settlement before this date to avoid this lawsuit today, we were told that settlement was not going to be allowed for us because it wasn't enough time, even though I was informed that I can have settlement done the same day. So now I'm being pulled like an example for the community, and I more than anyone have brought this park to your attention so that I can better the park. So the fee that's on here would completely bankrupt us and completely move everyone out in the park, which are senior citizens that have only Social Security income. Their lives are not jeopardized. They're not having crap coming back into their house. There's nothing wrong with the septic systems there now, since I've improved and corrected all the problems that were present when I purchased, including letting the New Mexico Groundwater know that I existed and that I had these problems. So I was not avoiding New Mexico Groundwater in any way. I was asking and begging for attention, for connection, or for help to improve system, which I have done. And I don't see anything pointed to what I have done there, because it seems to me that the New Mexico Groundwater was not aware of the way we purchased this location. We purchased it with all the leach lines having crap and in the road where children were stepping on defecations in the road. We fixed all that. You can show up to my park and you can see that there's not one problem with my park with leach lines or anything else. So the fee that's being charged to me right now, the saying that I did not comply, that I did not answer, that is not true. I have been answering. I have been asking people for more information to keep making this better for our community, since I'm the one that went in, cleared it of the crime, cleared it of all the bad infestation across the street from the police department, and cleared it up from all the septic and crap and trash that was in the park for years. This park was working for 30 years before I purchased it, and New Mexico Groundwater had no idea that this man was working illegally. I have been the one to give it to you guys and say, help me do this, help me make it better. And I have improved the lives of the people there dramatically from where it was. Right now, my park is very comfortable. There's no bad things happening in my park, and the water that was going over was due to a water break that was broken through winter. So the excess water we've had are water breaks through winter, that pipes that are broken, not in the pond system, that were above the pond, above the septic system. It didn't even go into the septic system. It was above the ground. And that was a water that broke from just a faucet that broke outside on several homes, not just one home. So I don't agree with the massive fine that I'm being charged because of the fact that I've done nothing but improve this location for New Mexico. I've done nothing but improve the quality of life for these people. I've done nothing but improve the septic systems there and leach lines so that we wouldn't have it like we bought it, which was completely full of crap. All the leach lines were full of defecation and disgusting everywhere. So we've done nothing but improve this place. And right now it is still working perfectly well. I don't have any gray water or any defamation of water or septic water coming out. Everything has been fixed and clean, and the people are living way better than they were when I purchased. So I don't agree with this massive fine because of the fact that it would be more than the cost of the entire property to begin with. And I just want help. I just want help. As all I'm asking for is help with someone that from the city of state official that is willing to stay with us and work with us to do our connection correctly. So I'm begging to please not do this massive fine, because I would literally lose everything we worked hard for 12 years, making this better for the community and for the people, which we have done. And there's no bad things going on in my park right now. I agree to do everything that we're requesting to do. I just need time to get it done and the right people that will help me do it. And I'm on that now, and we've been on that. Because of June of last year, everything has been basically, as you know, everything's been on hold for everyone in the country. And we're here now, and I'm working hard to find contractors that are not so backed up, because everybody I'm talking to is backed up for a month or two in time. So I'm trying to find the people to help me get what I need. I don't see a reason to put monitoring wells in if we're going to connect anyway. That's just an expense, not necessary. If I'm just going to connect, let's just connect and give me the right to do that without putting me in bankruptcy, kicking everybody out, and everything that we've done for 12 years is going to go for nothing, even though we have invested so much to make this better for everyone. So that's why I'm adamant in the sense of I'm here. I'm not avoiding you. I am here doing everything I can possibly do. This is not my career. I'm one woman trying to make sure that everyone's safe and making sure that that's my priority. And I'm not going about the fact that I'm not going to connect. That would be the best thing for us, and that's what I've been saying since the beginning, when the hole was in front of me and me begging someone to connect me. So I'm not avoiding anything, but the massive charge and fines will completely bankrupt us. It will completely not help the people or the community in any sense by making me go bankrupt. And why can't we just focus on what the problem is, which is connection for the community and for everyone involved, instead of killing me in the process for helping as much as I can. So I'm the one on my own. Mr. Patton obviously was bombarded by the 4 people working with him, and they cut him off and said that they would not work with him. And I'm the one that ended up in everybody's feet in the process. And I'm begging for help. I'm not avoiding this situation. I, more than anyone, want to make sure that we improve. But we are improving. We have been improving. And no one's been giving us any credit for where it was to where it is now and where I want to be. And that's not fair. It's not fair, because I'm one person trying to better this whole community, and I have done that. Right now, the police department is very happy with everything that they've seen, because we have cleaned the piles of crap and trash and shit that were in the park, and now you can live there beautifully with no problem. So my concern, of course, is for my family's living there right now, and I agree to improve and make better, but I cannot do this with this massive fine on my back that's more than what we even paid for our park and the homes there. I have no other recourse besides just trying to connect and make things right, and that's what I'm doing. That with all the pressure of all these people telling me I'm going to go to jail, they're going to close us, it's very hard to sleep. I haven't slept in 6 months, and good or bad, I am doing everything in my power to find the people that will help us. But because of all this, it's becoming so much harder, because now the bank and the possibilities of financing to connect are becoming irrelevant now, because no matter how much I try to connect, I am being told everywhere that I cannot. The city official says I can't do it without him, so he's nowhere in sight. Everything's done, and I'm being ignored left and right everywhere I turn. So I need help. and I'm here for help. And I'm here to beg you to please don't do this to me, because I am here to help everybody, not to be hurt and stepped on because I didn't understand one or two things. So I believe this to be wrong, because if you do this, then you literally close us all down. You close everything our family has worked for, my entire retirement, all for wanting to do what's best. So that's why I do not agree with your fines at all, because I, more than anyone, am trying to connect this system. And even though there was no connection, I have maintained a clean environment for the ponds. I have maintained it every year, pulling out the bad things from the ponds. There's no, or from the septics, there is no gray waters, there's no overcharges since we fixed it on 2012. So for 4 years since I purchased and let you guys know what was going on, I have been working very hard to make sure that nothing leaks, that everything's in order, that the only thing I didn't do was do the labs. And I honestly did not know that I had to do that. I left that to the contractor that was fixing all the leach lines and fixing everything, which he accomplished. So everything has been repaired and working in great order. I have had no charges to tell you, you know what, this is all messed up, because there has been none since we have had our permit. So we want to connect. We want settlement. We want for the penalties to go away, because we would prefer to put that income into making things better for the community and the park.
Okay, thank you, Ms. Arnelius. Are you ready to stand for cross-examination?
Yes.
Okay, Mr. Vigil, do you have any questions for Ms. Arnelius?
No, we don't. Thank you very much.
Okay. Do any of the commissioners have any questions for Ms. Arnelius?
Mr. Hearing Officer, Commissioner Hutchinson.
Yes, Mr. Hudson.
Ms. Arnelius, what is the current possibility of connecting to the sewage treatment facility?
Right now, I have a contractor that's willing to connect us and do all the required sizing and measuring for that. My problem right now is that I would have had the money I was financing to have the $100,000 needed for this, but because of this being so extensive to the court now, my bank is now needing a settlement for us to be able to go forward, because if nothing is resolved today, literally we are bankrupt and they will not renew the loan. So this is all stopping me from moving forward. I can't connect and move forward if everybody is stopping me to do so. And I'm trying to get the money necessary. I found the contractor that's willing to connect. We did find an engineer just recently, and he went to Lower Valley Water. He was willing to work with us for the engineer. He said that he would take it on, and somehow he went to Lower Valley Water, and he called me back saying that he was not going to help us. So I am feeling a little blacklisted here. I'm feeling like they don't want to help me, no matter how much I beg, how much I cry, how much I walk into there to make a scene. Nobody's paying attention to me. And I'm to the point now where I got this big fine, and I'm been the one screaming to the top of my lungs, please help me connect, because I'm the one that wanted it before the other mobile home park did. I was the one pushing connection before the other mobile home park. And when I was there fighting with the engineer, I paid him, and he says, we can connect you, let me find out what we need to do. I was ignored. And when I went to Lower Valley and kept knocking on the door, they closed up the hole, and I was just stressed out because I wanted to connect, and nobody was listening to me, even though I paid them.
Ms. Arnelius, can you hold there for a second? Yes. When I ask a question, I need a short response.
Okay.
And something that I note from your amended request for hearing is that several points in that document And I'll refer to this one on page 12 of 32 of your respondent's amended request for hearing. It says an offer of proof is made to this effect, referring to one of the alleged violations, and will be documented in a supplemental answer. Before this or any violation can be determined, respondent requests a hearing to present the documentation of the offers of proof asserted. Ms. Ornelius, do you have any paperwork, any document showing a offer of contract from a contractor to connect you to the sewage treatment facility? Do you have a written reply back from the sewage treatment facility denying you a connection? All I have heard so far is your verbal statements, but I see no factual offers of proof showing that these events have taken place.
The only thing that I provided for the engineer that came or that was working on the system when they were working on it in front of me, I provided the check to the gentleman that was in charge of the Lower Valley Co-op, and he took the check from me in that he said that he would come back and provide me information concerning connection. When he cashed a check, he left. He said he was going to talk to Lower Valley Water. He said that he was the main engineer in charge of the contractors for Lower Valley Water. I paid him. He did not provide me a contract. He did not provide me a letter. I just paid him the money to start the project, and he never returned anything. I went to Lower Valley several times and requested for his for him to call me, for him to show himself, for whatever. I asked for him to come, and they were saying that he was extremely busy and that he would get to me, and he never did. So I kept going to Lower Valley. That's the only person I knew to go to was to Lower Valley, and I kept asking them for something in documentation, and they wouldn't give me nothing. And when they started connecting the one next to me, I started to fight with New Mexico, Lower Valley Water, and basically informed them that that was not fair, that I wanted connection, and I was ignored. Basically, it was completely ignored.
Okay, so Ms. Ornelas, your answer to me is that you have no documentation as to your
check.
Statements other than
all I have is a check. Yes, all I have is the money I provided to the man to start the process. That's all I have is the check of that date when that's all I have.
And you have not submitted that in evidence for this hearing?
I believe I just did it this morning. I wrote in a declaration as well as a complaint to the New Mexico Groundwater, as well as a complaint to the Attorney General, and a complaint to Lower Valley as well.
Mr. Hutchinson, the answer is no. Nothing has been provided. This morning, she sent a letter which basically outlines what she said, but in much more of a concise form. It was signed. It was not notarized. It also appeared literally this morning. So, but no, there was no canceled check. Thank you.
Very well, Mr. Hearing Officer. I don't have anything further for the witness.
Are there any other commissioners with questions for this witness? Okay, Ms. Ornelas, at this point, you have rested your case in chief. There have been several questions on cross-examination. Is there anything that you would like to testify to based on the questions that have been asked?
Yes, on the
No,
settlement.
Ms. Ornelas, I'm
terms.
not finished. I'm not finished.
Okay.
This is not an opportunity for you to repeat what you've already said. This is an opportunity for you to present a rebuttal case based on the questions that were asked, or the question that was asked. Do you have anything that you have not already testified to based on that question?
No, just that I do have the council check, and I do have the council check for the other
Ms. Ornelas,
contractors.
you had ample opportunity to provide that in discovery, to file a witness list, to file an exhibit list. You have not. When Mr. Vigil filed for a summary motion for an expedited procedure, I served upon you my response, my order, granting it in part, but letting you know that I was going to bend the rules of this procedure to allow you to file a witness list or exhibit list up to 7 days before this hearing. You did not. And so you will not have the opportunity to present that check at this hearing.
Okay.
So if there's nothing further, Mr. Vigil, back to you for a moment. Did anything come up during the case in chief of the respondent that you feel the need to rebut?
No, Mr. Hearing Officer, thank you.
You're welcome. Then by the rules of 20.1.3.20, the general hearing procedures for a compliance order hearing, this closes the evidentiary record in this matter. And at this point, we have a quorum of the board members who have attended. So I ask them, as I asked before, would you like a hearing officer report, or would you like to deliberate?
So this is Acting Chair Gabriel Wade. I will open this up to other commissioners. I just also would like to point out that if we choose to deliberate, we also have the option, as was noticed, to deliberate in executive closed session. Well, I will kick off the conversation. I feel like this is a matter that we could begin deliberation on, and see where we go. In my opinion, I think that the much greater preponderance of the evidence has been established by the Environment Department. We have actual evidence. All the rules of procedure were complied with by the Environment Department. On the other hand, we don't have documentation from the respondent. It's very difficult to make a decision without that documentation. So I feel that the Environment Department has met their burden. And that their petition should be granted as asked for.
Mr. Chair, Commissioner Hutchinson.
Yes.
I would like to go back to the hearing officer for one technical thing to start off here. When we began the meeting, there was a discussion about the cost of the transcript, but maybe I missed it. Did we ever get that settled?
No, Mr. Hutchinson, we did not. And that was because it was not evident that the respondent had appeared. I looked throughout the attendees of the meeting, and there was nothing that indicated that she was here, nor was there the call-in user that is there at this point now. I asked multiple times if the respondent was there so that we could settle that issue, but the respondent did not make herself known. The rules say that the respondent is responsible for the court reporter, unless they can show by submitting documents that they are unable to pay for the court reporter, and that was not done either.
Okay, thank you, Mr. Chair. Thank you, Mr. Hearing Officer.
Sure.
Mr. Chair, I agree with you. And I would be prepared to make a motion, but I will defer to the other commissioners for any other deliberations or statements from the commissioners.
Commissioner Dominguez, your camera came on. Did you have comments?
I suppose so. I'll try to frame a little bit of this, because this has been kind of an ongoing issue for many years. This isn't something that just evolved during the pandemic and people weren't available. Parts of this go back to 2012. I happened to be on the commission at that point in time when the first settlement agreement came before the commission, because that settlement agreement, because it was a settlement agreement to a compliance order, that had to come before the commission. And as the department's counsel showed in one of the exhibits, then Chairman Tongate was the one that signed that settlement agreement. But that was a settlement agreement that the commission approved and was not carried out. So this matter's already been before the commission once, and the commission agreed to the conditions that were stipulated in that settlement agreement that would have waived a large part of that penalty had those conditions been met. And as Mr. Herman testified, those conditions were not met. So, I'm, without sounding like I'm being a little bit harsh, when things drag out for 10, 12, 14 years, whatever it is, I have a little more difficult time for it. And when the commission's already been down this path once and was basically burned on that, well, that's troubling for me. So that frames a little bit of some of the historical. This isn't just something that's propped up in the past year or two. And so, this is a little bit of a unique deliberation, more so than most all of them that we're involved with, because the party that has started this really hasn't presented the commission with anything to work with. The department has provided adequate documentation to meet the burden of proof of preponderance of evidence. So I would agree with my co-commissioners of their comments.
And, you know, another issue regarding time is because this is a violation and we don't know what the circumstances are, the longer this plays out, the worse the potential pollution that could be occurring. So I think that in of itself is problematic as well.
Mr. Chairman, this is Commissioner Thompson.
Yes.
You know, one of the things, Ms. Ornelas gives a very sympathetic presentation. However, as both Commissioners Hutchinson and Dominguez have pointed out, this goes back nearly 10 years. But also, if you look at the record, there has been a lot of correspondence back and forth, some successful, much of it was not successful. So this is not a new problem. And I'm real concerned that if we have grant any type of leniency, I have very little confidence that the problems will be remedied. And that is real troubling. If it was just the first instance of non-compliance with a request from the department, I'd be much more willing to look for a middle ground. But there's years and years and years of either non-reporting or incomplete reporting. And that has been notified, as has been testified by Mr. Herman and other staff members. So I have very little confidence that unless that anything would be better, that a more proactive approach to solving the problem would be taken if we grant any type of leniency.
Thank you. Any other commissioners? Okay, do I hear a motion then?
Okay, Mr. Chairman.
Mr. Commissioner Hutchinson.
I am prepared to make a motion.
Please do.
Okay. I move the commission grant summary judgment to the New Mexico Environment Department in the matter of Wqcc 21-04 due to meeting of the requirement for presentation of the preponderance of the evidence for the violations as stated in the compliance order, and assess a civil penalty of $265,050 to be paid through a schedule as determined by the department.
Thank you. That was a very thorough motion. Do I hear a second?
Second, Commissioner Dominguez.
Hey, Ms. Jones, can we take a roll call vote, please?
Vice Chair Wade?
Yes.
This is Council Son. I'm not sure if Commissioner Hutchinson used summary judgment as a technical term or as a term of art, but if he meant it as it's used in the rules of civil procedure that we could refer to for practical purposes, I don't think that would be appropriate, because for summary judgment, it would be a question of material fact, that there are no questions of material fact in dispute. If Commissioner Hutchinson intended simply that the commission uphold the compliance order because it's before the commission on review by the respondent, by Ms. Ornelius. If the intent is to uphold the compliance order that was issued with the specific assessment of a penalty in the amount of $265,000, I think that would be appropriate.
And I do agree. I know that Mr. Sanchez's job is to advise the commission, but a summary judgment would be before a trial. We are at trial. Both sides have presented evidence and the evidence has been weighed. And so I think the motion should be remade without that term in it.
I'm not sure that we need to remake the motion. I'll let Mr. Sanchez, give some more information. I took it to be that the motion was to uphold the compliance order in that amount. But Commissioner Hutchinson, if you'd like to clarify.
Mr. Chair, I will remove that part of my motion to clarify that we are ruling in favor of the New Mexico Environment Department's the New Mexico Department's compliance order.
Okay. Mr. Sanchez, if you feel that that's sufficient, then we can go to a roll call vote.
That is sufficient. Thank you.
Okay, I'll begin the roll call vote. We have a motion and a second. Commissioner Candelaria is absent. Commissioner Serkin?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Hutchinson?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Musharafi?
Yes.
Commissioner Modi?
Yes.
Commissioner Patton?
Yes.
Commissioner Rader?
Yes.
Commissioner Rader, I think I heard you, but could you speak up again, please?
Yes.
Thank you. Commissioner Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Timmons?
Yes.
Vice Chair Wade?
Yes.
Chair Stringer?
Yes.
Vice Chair Wade, the motion passes with one commissioner absent.
So I guess go ahead, Mr. Sanchez.
Vice Chair. Thank you. Before Commissioner Hutchinson beats me to it, let me suggest or propose that NMED Counsel Christopher Hill, pursuant to 20.1.3.20D, prepare a proposed order with proposed findings and conclusions. And because we have a pro se respondent, that he tender that document or that proposed pleading to the respondent pro se by United States Postal Service certified mail return receipt requested, with a specific deadline for her to comment or object to any of those proposed findings and conclusions or decretal provisions in the order. That way we don't have this go on for any undue length of time. And once that period has expired, I will go ahead and review the proposed order with findings and conclusions and prepare it in a form that is appropriate for the commission's vice chair to sign.
Mr. V. Hill, would you be able to do that as outlined?
Yes, I will. I'm actually looking at my calendar now to sort of take a look at when that might happen. But absolutely, and of course, we'll defer to what the commission and what the hearing officer says in any case.
Okay, thank you. So that takes care of the order, and I believe that would conclude this matter. So Moving on to the next matter on the agenda. This would be item number 9, next meeting and expected upcoming matters. But I had also moved at the beginning of this meeting, had moved the WQCC triennial review discussion into this segment because it is an upcoming matter. Mr. Chikalian, did you want to open the discussion on this?
I'd be happy to.
Okay.
An update, the parties, and there are about 6 or 7 parties in this matter, have filed their direct pre-filed testimony, technical testimony. It is lengthy. The next deadline will be in a few days for the parties to submit their rebuttal pre-filed direct testimony. On July 13, the hearing will begin. It is expected to go at least several days. By my conversations with the parties, and we do have a conference next week to iron out the order of testimony and how they're going to summarize their testimony. It will most likely take the rest of that week. I don't think it'll go past Friday, and if we're lucky, it won't go to Friday, but it easily could go 3 or 4 days. And I wanted to make everyone aware of that.
If I can, just real quickly, if there are commissioners who cannot commit to that time frame, will you please let Ms. Jones know right away? And I think the message here is that you got to clear your calendar if you intend on attending this meeting, because it will take several days.
Agreed. The other thing I wanted to put out there, and I don't know how Mr. Sanchez feels about how far I go into this, but again, the commission and the rules for rulemaking 20.1.6 leave open the possibility of the hearing officer generating a report. The report would be based on findings and conclusions supplied by the parties and closing arguments supplied by the parties. And that may be helpful for their decision-making, or the commission may find that, in fact, by sitting through all the evidence and hearing it firsthand, that they won't find that helpful. I leave that open for, I guess, discussion at the end of the hearing, but it is something that's on my mind because it will take several months to gather that evidence and go through the transcript and produce a report. So I just wanted to bring that up, and that's all from me. And it was a pleasure conducting these 2 hearings today. And thank you very much.
Well, thank you for your time today conducting these hearings. Regarding the report, I've learned a little bit of the history of these reports. I'm inclined to say yes, we would want a report, but I'll let maybe Commissioner Dominguez or Commissioner Hutchinson weigh in on, how we used to handle these in the past.
This is Commissioner Hutchinson. Yeah, Larry's going to let me go ahead of him. I was paused long enough to give him the opportunity to start. In the last triennial review, we did have one of the best reports that I've witnessed in the several triennial reviews that we've been through. I think it would be very helpful for our hearing officer to maybe take a look at that. In addition, our counsel, Mr. Sanchez, spoke with previous hearing officers and developed a list of suggested inclusions in a final report that I think were well suited for giving the commission a good path to follow in doing our deliberations. It's very useful to have each section broken down as we go through and have the various parties brief statements or their brief positions on language. So that's something that was very helpful in the last triennial review. I certainly don't want to give our hearing officer the task of making recommendations. I think that the commissioners read through the evidence and listen carefully to the testimony and rebuttals, that they will have enough information upon which to make their own decision. And it's often better that be conducted in that manner. And I will leave it at that. And I'm sure Commissioner Dominguez has maybe something to throw in there.
Well done, Howard. So thank you. Just add a couple of points to frame things for the commission as whole, because we have a lot of people that have not been through this joyous process before. We have not had historically an exact template to work from. We've had some triennials where we did not have a report. There could be some reasoning for that. And it could be when we get through the end of the testimony for triennial, that all the parties may be close to being on the same page. And if that was the case, potentially a report might not be necessary, and we could indicate to the hearing officer accordingly. Considering the multiple parties on this, that might be a long shot there. So I think the best thing to do for the sake of our hearing officer is to approach it from I don't want to say a worst case scenario, but let's just couch it in that way, that we're probably going to need this so that our hearing officer can be looking at stuff going through the hearing in order to prepare that report. So what are the key items? Howard referred to that report from the last triennial, and it was pretty extensive. I will also play devil's advocate on that and say they can be both good and bad. If the hearing officer reports get so extensive, it's no different than looking through the pre-filed testimony, etc. So there's kind of that fine line of summarizing things that then is helpful for the commission so that they don't have to have 5 or 6 sets of testimony laying out as they try to prepare thoughts and go through deliberations, if that makes sense. I would completely agree with Commissioner Hutchinson regarding recommendations. Triennial's a little bit different than some other hearings. There are particular hearings that actually require the hearing officer to make a recommendation. triennial is not one of those. Triennial is really dealing with standards. Setting a standard is the commission's responsibility. So every one of the commissioners that has volunteered or been told to sit on this commission, that burden sits on your shoulders. And so I want you to keep that in mind. It's not as simple as us having a good hearing officer that ties it in a nice bow for us. We still have to do our due diligence. So with that said, I'll also ask or refer to Commissioner Wade's earlier comments regarding missing parts of the hearing or a day of the hearing. In order for commissioners to be part of the deliberation, at the beginning of deliberations, you will have to attest that you read the transcript, you've reviewed everything that you missed in order to participate in deliberations. And that's only fair to all the parties so that there's not some bias just because a particular person missed somebody's testimony. So keep that in mind when you're looking at your schedules, and also keep it in mind from the standpoint that the chair will have to make sure we have enough commissioners available for deliberation, meaning a quorum, to make a decision. So I think I have thrown out enough bad news there to at least maybe catch someone's attention. But these are things that you need to know ahead of time going into this. So I think I'll leave it at that unless there's questions from the hearing officer or from council session.
Mr. Dominguez and Mr. Hutchinson, I have a copy of Felicia Orth's WQCC 08 hearing officer report for the triennial review. I do not have a copy of her most recent one, and I think you must be referring to her when you say that it was, no. Who?
I believe, and Commissioner Hutchinson will be quick to correct me. I think the hearing officer for the last one was Anderson.
That's correct.
Is that correct?
Okay.
And you will probably see some differences between their styles. But Felicia Orth has been around the block 2 or 3 times, so it's a good one to look back at.
Perfect. I'll find Mr. Anderson's as well. Thank you.
Hi, Chair Wade. This is Councilor Sanchez. May I comment as well, please?
Yes, please.
Thank you. I too would be as hopeful as Commissioner Ramirez indicated that there may well be the possibility of there being near consensus in terms of what amendments need to be made to the surface water quality standards. But I would ask the Commission to keep in mind that we probably have a reality that argues against that. If the Commission will recall, Triad filed a separate petition primarily because they felt that the NMED proposed amendments did not encompass the amendments they were contemplating, and also the whole logical outgrowth question. So as much as I'd like to be hopeful that we won't require a hearing officer's report, I think we have a very real situation where that's indicated, if only because I would suggest that hearing officer Shukalen may in his report be able to inform the commission what matters remain by way of amendments or proposed changes remain in the present proceeding or 2051 that might need to be addressed separately in the triad petition. And I also spoke, just by way of housekeeping, I spoke with Alicia Orth, and she did not do the 2017 triennial review report, but I think she's done all the prior ones. I would be glad to share with, unless he wants to speak with Ms. Orth directly, I'd be glad to share with Hearing Officer Caitlin what she sees as important pillars or cornerstones in providing an effective and useful report to the commission. And just one final comment, Hearing Officer Caitlin, I looked at your procedural order that you issued on November the 9th and that timetable for deadlines, and it pretty much follows, I think, what's been the common practice. That what I didn't see, and I just offer it by way of observation, that after the hearing officer issues his or her report, typically there's a 10-day period that's allowed for comment on that hearing officer's report. And then finally, of course, the public hearing on the actual rulemaking would need to happen subsequent to that 10-day comment period. I'd only invite you to think about possibly amending your timetable to include a post-submission of the hearing officer's report comment period. Thank you.
Okay, well, I'd like to remind everybody that I will not be the chair next month. So we don't have to make a decision necessarily now, but it sounds like Mr. Chicali and I would be prepared to draft an order. And I would think about that time period for the public comment on that. But I will defer to Chairperson Stringer, who will get to have this as the first hearing or the first meeting as chair. Is there anybody else who's got comment on this?
Mr. Chair, this is Commissioner Hutchinson again.
Yes.
I just want to note that in instances where we've had disputed elements of standards following the triennial review, there have been litigation initiated challenging the commission's decisions. And I think, for the court and the record, that it's very helpful to have the sequences of motions that are made included in the report from the hearing officer. So I think at a minimum, the documentation of those motions, and we've already had some already, and I would hope that we don't get through a triennial review and render a decision and then have the court smack us back into another hearing. So that's the other criteria that all of the new commissioners need to keep in mind, that we need to follow the evidence and be very careful in coming up with rulings on uses and standards.
Definitely appreciated, Commissioner Hutchinson. So something like a pleadings record would be useful.
Mr. Vice Chair, this is Commissioner Thompson.
Yes.
And this may be a question more directed towards incoming Chair Stringer, but are we going to have this hearing via video teleconferencing, or is this, does the state have any intent to go back to in-person hearings for organizations such as ours?
I have no direction as far as that goes. I would make the assumption that we're going to be via, WebEx again, or potentially some hybrid, but I have not heard one way or the other. Commissioner Stringer, I don't know if you've heard anything.
Mr. Chair, Commissioner Thompson, that's the status that I know, is that we're hopeful that the public health orders and guidelines will change, but at this time, we don't have enough information to proceed with a strictly in-person meeting. So I would plan for either a hybrid or a WebEx meeting. And just, I wanted to note, I missed, my computer crashed briefly, so I missed a few moments of this discussion, but I will catch up with Vice Chair Wade on what I may have missed.
Thank you.
I might also note that the public notice in the register was published, about 30 days ago at least, if not longer. So I don't know how you would switch at this point to non-WebEx.
I think that's a good point. Probably
Vice Chair Wade.
Yes.
Commissioner Dominguez, this is, I think we've kind of put that to rest, but before we lose our hearing officer, when we move on to the next agenda item, I did want to quickly recognize his efforts regarding WQCC 21-04. I think Mr. Chakalian did an outstanding job of trying to herd cats. With that one, out of my career here, that one ranks up there in the top 5 or so of unique situations. And I thought he was very professional and did a good job of keeping things framed so that the commission could focus on the facts at hand. So I appreciate your efforts on that, Mr. Hearing Officer. That's all I had.
Thank you, sir.
I very much agree. Those are not easy ones. And to say that that's in the top 5 of Commissioner Dominguez's career, that's saying something. Shall we move on to the next agenda item? Does anybody else have anything on this item? So that takes care of agenda item number 9, upcoming matters. The next item would be to adjourn the meeting. So does anybody else have anything before we adjourn? Nope, just reminder, I'm already seeing some emails come in, so during that week in July, make sure to let us know if you're going to be available and maybe when not. Otherwise, this meeting is adjourned.
Vice Chair Wade?
Yes.
Before everybody hits the stop button, I thought I would quickly ask the commission administrator if there's any other upcoming matters that we need to be aware of that we haven't already covered.
There are none. Thank you for asking.
Okay, thank you for that.
Okay, last chance. Anybody else? All right, we will adjourn this meeting. Thank you, everyone. Bye.
Thank you.